Okay. All right, good morning, everybody. The time is 9:01, and I call this Citrus County Code Compliance hearing for Wednesday, August 20th, 2025 to order. We follow an agenda for these hearings. The first item on the agenda is the call to order. The second item on the agenda is the pledge to the flag, so I'd like to ask you if you join me in the pledge to the flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you, everybody.
Good morning.
Good morning.
If any person decides to appeal any decision made by the Code Compliance Special Master with respect to any matter considered at this public hearing, he or she will need to ensure that a verbatim record of the proceedings is made, which record shall include the testimony and evidence upon which the appeal is to be based.
Okay, thank you. The next item on the agenda is approving the minutes from the last hearing, which was on Wednesday, July 16th, 2025. I have a copy of the minutes as currently formulated. Are there any proposed modifications, deletions, changes to them? There never are. I'll go ahead and approve them.
There are no staff updates at this time.
Okay. Good morning, everyone. My name is Christian Waugh, and I'm a licensed Florida attorney acting as what is called a special master. That's a fancy title created by law, but what it means is that Citrus County has hired me to preside over this hearing. What I'm going to tell you during this opening statement applies to all of your hearings, so I would appreciate it if you'd pay attention. When your case is called, please come forward. You will be placed under oath. If you are appearing at a hearing like this for the first time, the county will call its case, and I will allow the county to present its case. You will then have an opportunity to cross-examine any of the county's witnesses, and you will have an opportunity to present your case regarding the violation. That will be your opportunity to present evidence and to make legal argument. It is important that you take your time during this process because it is likely going to be your only chance to make your case. I will also ask whether or not you are contesting the violation. If you're not arguing that a violation exists, I will assume a factual basis for the violation and proceed to ask you how much time you need to fix it or to work with the county. This will help save time for yourself and others, but you are by no means required to do so. If you oppose the case or simply want to be heard, you have that right. At any time during the hearing, I may have questions of parties, witnesses, or staff. Before issuing a ruling, I will ask if there are any members of the public who wish to speak. If there are, the members of the public will have one opportunity to speak per case. Such right to speak is not unlimited, and public comment should be focused on the case and made as succinctly as possible. Although persons may be upset or even passionate about what they have to say, all witness testimony should remain civil, and you will not interrupt other witnesses, parties, or attorneys. In most instances, if you are found guilty of a violation, the law requires that you be given a time to comply before any fine begins. You must fix the violation by the date that I give, or a fine will accrue for each day that you remain in violation. The law allows Citrus County to impose that accrued fine as a lien on your property, and the county has the right to foreclose on that lien or seek money judgment against you after the lien has been recorded for 3 months. I encourage anyone here who has questions about their rights or remedies to seek their own legal counsel. In all cases in which I find that a violation has occurred, I will impose all costs required by county law. I incorporate this into all of my orders as standard provisions. If you bring your property back into compliance during the time that I allow, that cost will remain minimal. But if you do not timely fix the violation, you will be responsible for additional costs. Let's see. You do have the right to appeal any order that I make today, as may be provided by law. Thank you for your attention.
First case on the day's agenda, Margarita Buchette, case number 2025-287, Code Officer Alan Jonason, page 8 of your agenda. Brittany Cofield, Water Resources expert on the case.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Please state your name, ma'am.
Margarita Buchette.
Thank you.
Good morning, ma'am.
Good morning.
Good morning.
Good morning.
Alan Jonason, Citrus County Code Compliance Officer. This is case number 202500827, conflict with Central Water Facility, section 42-39B. Address of the violation is 3199 East Dawson Drive, Inverness, Florida. Property owner is Buchette Margarita. I have good service via posting the notice of hearing on the property and posting at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, copies of the notices from utilities for water connection 365, 270, 180, and 90-day notices, and the final 30-day notice. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the pre-hearing order, a copy of the notice of hearing posted on the property, and a copy of the posting affidavit.
Okay, so this is not one where it's uncontested?
No, not really.
Okay,
sir.
all right, well, hold on a second, sir. If you would, can you give me a narrative of what this case is about?
So I will refer to the expert from utilities,
Okay,
Brittany Cofield.
great.
So she had a 365-day notice to connect to our water. She has signed a lien agreement to
I
start
don't
the
have any other
process.
choice. I had to sign it
Well,
because
ma'am, you'll get a chance. Let me just hear from them.
To start the process. So we have a meter install work order out in the field waiting for a meter to get installed. She just has to do the plumber portion now.
So you already have an it's the county's position that the county already has a signed lien agreement?
yes.
Yes.
And what are you waiting for exactly?
So the meter's waiting to be installed now.
The
and
meter
then-
hasn't been installed.
No, we just put that, once she signs the lien agreement, that's when we can put the meter install work order out in the field.
I thought you said you already had a lien agreement.
Yes. When did she execute it? That was about 3 weeks ago. I don't have that date. It can take, I have it as ASAP, so it could take like 3 to 6 weeks, hopefully 3 weeks on the better side.
And for me to pay,
I'm sorry, well, and hold on. I'll handle it. But so here's the thing. I guess what are you alleging is the violation?
She still hasn't connected.
She hasn't connected.
Yes.
Despite the agreement, and that's the county's case.
Yes.
All right, now I would definitely like to, actually, before we get into these exhibits, can you tell me what's happening from your perspective?
well, it's a lot of money. Plus, to connect it, they went yesterday, it's $1,500 plus the $19.95. That's a lot of money.
Right.
Now, I spoke to her and she told me that I could pay $20 monthly. But what about the connection, the $1,500? That's where I have a little.
Right, so in other words, there hasn't been a payment plan offered for the
Not
connection fee or anything like that?
Not yet, no.
Okay. Mr. Johnson, I guess let's go through the exhibits.
Sure.
And so, ma'am, I'd like to ask you to take a look at these documents and let me know,
That you were sent in the mail.
well, and so let me know if you have any objections to them being evidence in this hearing, because I want to look at them.
Oh, boy. Your property located, according to the record, instated by county. Well, I can't read all this right now. Your property
Yeah,
is so
I mean,
much.
well, take your time. I mean, here's what I want to know is if you have any legal objection to these documents, or heck, if you've seen them before.
No, here, listen, I'll pay it, but it's gonna be little by little, payment, monthly
Well,
payment.
let's hold on a second. Let's not get ahead of
That's the only
ourselves.
thing I could pay, yeah. Sure.
Let's just take a look. All right, I'm just going to take a look through these documents very quickly. Give me a moment. Now, when you talk about the monthly payment plans, is that through the Citrus County State Housing Initiatives Partnership Program, or is that a different thing?
So the lien agreement signed through us, that is the monthly payment she's referring to. It's gonna be about $21 a month. And that's towards the connection fees. So
So that
she's
is
gonna
towards the
be on a
connection.
monthly payment plan for the connection fees. So what she's referring to is the plumber costs.
Okay, all right,
That's too much.
that makes sense. County's not willing to subsidize the plumber cost or pay for it.
They should.
No, I don't know, I'm just curious. Does the county know, or is?
No, it's actually an ongoing issue with the state. The state's requiring us to have all these connections, and then our citizens are stuck with additional costs because the state are requiring the county to connect people. So we're
Wow.
the people stuck in the middle.
Okay, that's good to know. Doesn't sound like there's a lot of debate about the financial hardship, in other words, so. Okay, what's the county requesting from me?
$50 per day.
After a time I deem sufficient to?
Yes, sir.
Okay. Ma'am, so I want to give you a chance before I ask for members of the public. Here's the deal. I mean, the law is pretty clear about what it says. There's a certain amount of time from the date of you receiving these notices that you have to connect. So, and it doesn't seem like you argue with that. You're arguing with the fact that, hey, this is kind of impossible because I can't afford to do what they're requiring me to do, right? Mm-hmm. Okay. How much time would you need to actually be able to afford what you're talking about?
Okay, that side, I could pay monthly. I could
Right.
Yes, that's
that.
Right.
set up.
But the other side, the connection that they charging me $1,500.
Yeah.
That's where I'm stuck.
I know, and I'm asking you, how much time would you need to do that?
A year?
Is there anyone from the public who wants to be heard on this case? Do you, does the county have any current health, safety, sanitary issues? Like, are you aware of any septic failing or anything like that?
I am not. No, sir.
All right, so the original notice in this case was, all right, so the first is actually quite some time ago, well over a year ago. And then there were notices received on July 12th, October 14th, January 14th, March 19th of this year. So this has been going on quite some time.
I did call them when I got that notice. I think it was I'm not sure if it was last year. I did call them and I told them, listen, I don't have, they told me $2,000. And I told them, I don't have $2,000.
What I'm saying is, if it needs a year, you needed to start.
Okay,
So what I'm gonna do is first of all, is there anyone from the public who wants to be heard on this case? I think I already asked that. I don't see anybody. I'm admitting these documents as exhibits A and B. I'm gonna find that the property is in violation. I'm gonna give you 6 months, okay? And if it's not brought into compliance as ordered in 6 months, it'll be $50 a day. Okay?
Thank you.
All right, good luck.
Okay. How much is gonna be monthly?
That's the.
Next case, Janie and Eugene Kelly, case number 2025-824, Code Officer Alan Jonason, page 24 of your agenda. Water Resources, Brittany Cofield, expert on the case.
Alan Jonason, Citrus County Code Compliance Officer. This is case number 2025-00824, conflict with Central Water Facilities, section 42-39B. Address is 3056 East Dawson Drive, Inverness, Florida. Property owners Kelly Eugene and Kelly Janie. I have good service via posting the notice of hearing on the property and posting at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, copies of the notices from utilities for water connection at 365, 270, 180, and 90-day notices, and the final 30-day notice. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the pre-hearing order, a copy of the notice of hearing posted on the property, and a copy of the posting affidavit.
Okay. Without objection, the documents are admitted as Exhibits A and B. Please proceed.
On 27 May 2025, I received this case for failure to connect a public water system and found that there was no permit to connect. A notice of violation was issued on 28 May 2025. On 1 July 2025, I contacted utilities and found that no connection has been made and no waiver had been given. As of my final inspection on 19 August 2025, there has not been a permit applied for or any contact regarding connection to the central water system. Expert on the case from utilities, Brittany Cofield.
So I've had no contact from them.
Do you have any reason to believe that the house is unoccupied? I mean, do you have any information about that? Okay, all right. Well, there's no one here on behalf of the respondents. Is there anyone from the public who wants to be heard on this case? I don't see anyone, so what I'll do is I will find that there is a violation based on the evidence I have in front of me. I'll grant 30 days to bring it into compliance, and if it's not brought into compliance as ordered, I assume the county's recommendation is $50 a day, and it'll be so ordered. Thank you.
Thank you.
Next case, Jessica M. McCarthy, case number 2025-825, page 27 of your agenda. Expert on the case, Water Resources, Brittany Cofield.
Good morning, ma'am. Please, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name.
My name is Erin McCarthy. I am representing my mother, Jessica McCarthy.
Okay.
She's deceased.
I'm sorry?
She's deceased.
She's deceased, okay.
Yes, sir.
Do you reside at the property of 14 South Charles Ave?
I do.
Okay, and are you an owner of it?
No. The house is currently in probate. It was owned by my mother. She did not leave anything behind as a will. She owned the house. We're currently in probate, and I have brought some documents just in case.
Are you an heir of the estate? Are you an heir, like, are you a beneficiary of your mother's estate? Does her property go to you?
No, sir. She did not leave anything like that behind.
Okay, well, what I mean, do you have any siblings?
Yes.
Okay, do they also live on the property?
Yes, sir.
Okay. The point of probate is to ensure an orderly transition of the assets and also to pay creditors. But what I'm getting at is, and I don't know, and I'm not giving you legal advice, but it sounds like, well, just so you're aware, even if you don't have a will, you can still, through probate, the property might still go to you. So that's why I'm trying to establish what your standing is. It sounds like it might be shared among siblings. I don't know. Not important. I think you have standing to be here. Please proceed.
Yes, sir. Alan Jonason, Citrus County Code Compliance Officer. This is case number 2025-00825, conflict with Central Water Facilities, section 42-39B. Address of the violation is 14 South Charles Avenue, Inverness, Florida. Property owner is McCarthy Jessica M. I have good service via posting the notice of hearing on the property and posting at the Lecanto Government Building. I'd like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, copies of the notices from utilities for water connection at 365, 270, 180, and 90-day notices, and the final 30-day notice. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the pre-hearing order, a copy of the notice of hearing posted on the property, and a copy of the posting affidavit.
Okay, so ma'am, I would like to ask you to take a look at these documents and let me know if you have any objection to them being evidence. And of course, when it's your turn, I'll take a look at what you've got as well. Is that the Darmientos out there? Yes, sir. Okay, all right, welcome back. Any legal objections?
I'm not exactly sure.
Yeah,
never
no,
done
I
this
mean, that's
before.
fair. Yeah, most lawyers
do
aren't sure either.
apologize.
That's fair. I mean, do you have any reason to believe these documents are fake for any reason?
No.
Okay.
No, sir.
All right, so, thank you. All right, without what I construe as an objection, I'll admit them as evidence, Exhibits A and B, and I'll let the county proceed with its case.
On 27 May 2025, I received this case for failure to connect to public water system and found that there was no permit to connect. A notice of violation was issued on 28 May 2025, and on 1 July 2025, I contacted utilities and found that no connection had been made and no waiver had been given. As of my final inspection on 19 August 2025, there has not been a permit applied for or any contact regarding connection to the central water system. Expert on the case.
Hi.
Welcome.
We've had talks on the phone afterwards, after the 365 ended. I believe you're having financial trouble as well. So we do have the lien agreement option that you can go into as well. That's about $20 a month. And then we also have, but you have to do the plumber connection cost. And so I believe that's going to be her financial trouble
Okay,
there.
well, you know, we're just here to resolve whether or not there's a violation, frankly. How y'all resolve it outside of here is between y'all. So, Ms. McCarthy, if you want, you can cross-examine these witnesses, or I can just talk to you about what's going on your side. Do you have any cross-examination?
Not exactly sure what that means.
It means, do you have any questions for them?
Not entirely, no.
Okay. I mean, so tell me about your side. What's going on and what do you need?
Basically, my mother did own the house. She was married, not to my father. She passed away in 2023. Now, she got sick. It was very sudden. So nothing was really planned. So it's kind of been pretty chaotic. I do have a younger brother and then an older sister. Currently in the house, it's me and my sister and my brother. Now, me and my sister both work full-time, and my brother is in school. He's in middle school. My aunt, which was my mother's sister, she is the one who has represented in the probate case in order to get this going for us. Honestly, I had no idea anything about this until the hearing for the notification for this one, for this court case, because unfortunately at the time, my mother's husband had lived in the house. He no longer does. Long story short, not the greatest person, not very responsible. So I had no idea about this. I just knew that I should be coming, and so no one, I should stand here because it's better than no one standing here. Honestly, I have no idea what any of this is. I know that me and my sister cannot really afford this.
Sure.
Especially with the cost of the probate. I understand. I do remember speaking. I think I spoke to you about it's either when it comes to selling the house, because we do plan on selling the house. We cannot sell the house until either we get this done or the buyer agrees to get it transferred over.
Okay, well, I don't know that that's true, but I encourage you to talk to a lawyer about that. I mean, these can end up as, clouds on title or things like that, but I'm a little skeptical if that's been represented. Yeah.
I have the questions of, am I even able to do any of this stuff since I'm not the owner of the house?
That's a good question. The answer, I'm sure, is yes. I mean, I'm sure that someone can connect. I don't think the county, frankly, probably cares who does it, but I don't know. Does the county care? Does the county care who allows for the connection on a house if it's not the owner? Or determined by a court to be the owner? No. So I think what we have here, these do look like appropriate notices. And, one of the things that I've said in hearings before is that in a probate is used to do the orderly transfer. It's meant to put title in the name for public records purposes, but upon death, it's supposed to go automatically, especially a homestead. A homestead, and in the state of Florida, there's certain rules about how it automatically goes to the heirs. there's options about how that works. But in any event, I am going to find that there's probably a violation. I want to know if there's anyone from the public who wants to be heard on this case, but I think what I'm more inclined to do is give a certain amount of time, just like on the last case. And, you know, it could be done by y'all. I don't know what kind of assets exist in the estate, if any, to handle it, but I'm going to grant 6 months to bring it into compliance. I do find that there's a violation. Like, whether we like it or not, the code is clear about having to connect to these central systems. And I've never heard a lot of people jumping for joy, but in the long run, it's usually considered a good thing and a public benefit. If it's not brought into compliance within the 6 months, it'll be a $50 fine. I assume that's the county's recommendation, and that's that. So you've got time.
Thank you.
Okay, thanks.
Thank you.
Next case. Stephen Todd Walker, case number 2025-899, Code Officer Cody McGuire, page 39 of your agenda. Expert on the case, Land Development Director Joanna Coutu.
And Your Honor, on this one, we have a no contest. However, we do not have an agreement as to the time to cure or the amount of fine.
Okay, I think that is okay, probably, we'll see.
Do you swear to tell the truth, the whole truth, and nothing but the truth so help you God? I do. You don't have to. Could you please state your name for the record?
Austin Daly.
Okay, good morning, sir. And are you an attorney or, okay, all right. What are the terms of, I mean, so it's a no like, okay, there's a violation.
They agree there's a violation. At this point, we have a chain link fence that is 6 feet tall, and on top of that is a bit of fence that is barbed wiring. So we have a violation that the fence is in excess of 6 feet tall, and we have a violation that there's barbed wiring in a residential area, which our code does not allow.
Well, that's a shame.
What
What are you going to do without barbed wire?
The zombies can get in. Short of that, when I was speaking with Mr. Daly before court today, his client's concern is that when the fence was constructed, somehow the barbed wire was like engineered as part of the fence, so you can't just take it
Rip
off.
it off. Mm-hmm.
And they are doing construction, so he indicated he wanted it to be there for, I think, about 6 months. Since barbed wire is not allowed at all in residential, the county wasn't in agreement with that time frame. We wanted less time, so that's why we couldn't come to an agreement as to the amount of time. Okay. He indicated his client's going to cure before we have to get to a fine, but at this point, the county's recommendation is $200 a day if it's not fixed within the time to cure.
Could I see the photos? Do you have photos? Can you show them to Mr. Daly? Sir, let me know if you have any objection to them. In determining time and fines, it's helpful for me to actually see the photos.
No objection.
Okay. Thanks. Bless you. I see what they're saying about the barbed wire. I mean, how is it going to get taken down? Is a whole new fence going to be put up, or how is this going to work?
They would have to take the fence apart and basically reconstruct it. Yes, sir. Is this all brought just under one code section?
Yes, sir.
3150?
I don't remember the exact subsections
Mhm.
of B and D, I believe. A.
A is the barbed wire? Subsection A of 3150? Is that on the notice of violation? It is? All
It
right.
is.
Why don't you take a look at it? Where is subsection A on there?
Oh, no, it's not A, it's B and D.
Okay, I see that. Well, I guess what I'm trying to,
Is it A?
I'm not gonna make this more complicated, all right? My concern is that I don't think it takes 6 months to get rid of the barbed wire part. You know, I understand. So why is barbed wire necessary here?
So, yeah, if I may give I'll keep it brief, but
Yeah.
this property is zoned rural residential, which is why it's falling under this code section that doesn't allow for barbed wire. It is on Suncoast Boulevard, a 60-mile-an-hour segment. It's within 500 feet of general commercial property, 800 feet of PSO, and within 900 feet of heavy industrial property. So it is on a heavily trafficked, highly public stretch of road, not in a neighborhood. During construction, certainly they would prefer to have barbed wire for security. They've got materials on site, unattended on this heavily trafficked area. So that is why the request for 6 months. It would not take 6 months for them to get a contractor out there to reassemble the fence. The request for that time period is acknowledging that it's not expressly permitted under code, but that this is something that makes sense. And I think, you know,
It might, but I think that I really don't argue that it makes sense. The problem that I have is if I granted that, it would be like a variance through the back door.
Sure.
Without the notice, without the hearings, without the, I guess that's my concern. And then anytime someone wanted to get around this, it's almost like a right. They're gonna get barbed wire on their fences, and then I'm gonna give 6 months, however long they need to do the construction on the property. I can't do that. Go ahead.
Sorry, yeah.
Apologize, Janie, Land Development. I don't know when construction is going to commence. They applied for a permit in June. In July, it was denied by every single reviewer. It was very, very poor plans. I don't know when we're going to get another resubmittal to even issue a permit to start construction. So kind of taking that into.
I've never heard you characterize things as very poor plans in a hearing before.
Rarely have all single reviewers, every single one deny. Yeah.
Okay. What's the county's recommendation?
$200 per day.
Is there anyone from the public who wants to be heard on this case? Okay. I just don't think this is that complicated. I'll grant 2 months, and if it's not brought down in 2 months, it'll be $200 a day. All right. Thank you.
Next case on the agenda, Brass Boys Enterprises, Inc., case number 2025-829, Code Officer Alan Jonason, page 10 of your agenda.
And Your Honor, I have been notified this is a no contest case. They have agreed as to 60 days to cure and $150 a day fine thereafter, and we do have counsel.
Okay. Good morning, sir. Can you put your name on the record?
Good morning, sir. Ethan White with Klein & Klein Law Firm on behalf of the defendant.
Okay. Let's see. And what page of the agenda is this?
10.
10.
Page 10.
All right, thank you. Can you give me the terms of the resolution again?
$60 a day and $150 a day fine thereafter.
60 days and $150 a day?
Yes.
Okay.
It's only high grass, but it's a golf course, so there's a lot.
Okay. Is the golf course being used? That could be
No, sir.
a new kind of rough. Okay.
What's,
I mean, it sounds like a potential attraction, but also potentially a nuisance. So I have no reason to oppose that resolution, I don't think. Is there anyone from the public who wants to be heard on this case? Yep, there are people. Okay, so let's let everyone have a chance to have their say, as is required under the law.
Ma'am, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Please state your name.
Sissy Campbell.
Thank you.
And ma'am, if you would, try and speak into the microphone just to make sure that your comments are picked up and on the record.
Okay.
What do you have to say?
Even when a golf course isn't open to the public, the owner still needs to do their part. The grass and plants keep growing, and it's so important to stay on top of regular maintenance to prevent the overgrowth and keep the land in good condition. If the owner neglects this, pests like mosquitoes can become a problem. Not only are they annoying, but they can also spread diseases, which is bad for everyone. That's why the owners must stay vigilant with maintenance and address environmental issues like water use and wildlife habitats. Talking with neighbors and the community helps everyone work together to minimize the space, responsibility, care, and environment for our shared areas safe and pleasant. The golf course is surrounded by homes in our community, and when the owner lets the course go and all those buildings that should be condemned, it affects us all. The condemned buildings also leave potential areas for squatters and their pets to live. They are hazardous and should be condemned. The humans and dogs should not be camping in them. And residents of Connell Lake Estates, as well as the Sheriff's Department of Citrus County, are aware that there is in fact a person and his vicious dogs living in one of the buildings.
Okay, thank you, ma'am.
Thank you.
Is there anyone else who wants to be heard? I thought I saw other hands, but okay. Now will be the chance.
Good morning, sir. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name.
Steve Grumka. And I'm just here because I live on the golf course, and I've been seeing the way it's been neglected since they closed the course. But it goes beyond that. Before he closed it, it was still being run down where he wasn't putting anything to try to upkeep the property. The bathrooms on the golf course, the one on the 4th hole and the one on the 13th hole, were in total disrepair, where, you know, you wouldn't even want to use them. They were in that bad shape. The maintenance building, you have panels that have fallen off and have never been repaired. The roof is torn apart on the maintenance shed, where he replaced the roof on one of them, but the other one he hasn't. He closed the clubhouse that was originally there because it wasn't being maintained, and they moved the clubhouse to the restaurant. And I just think that, you know, it's just being totally neglected by the owner, and he doesn't care about what happens to the property now because he didn't care before. That's all I have to say. Thank you.
Okay, thank you, sir. Is there anyone else who wants to be heard? Ma'am?
Truth and nothing but the truth, so help you God.
Yes.
Your name, please?
Elaine May.
Thank you.
Good morning
Good morning.
to all.
And again, ma'am, I'd just make sure that you get that microphone down
Okay.
towards.
And I've got allergies. so-
Yeah, well, join the club. There's a lot of folks. All right.
I live at 1224 North Fox Run Terrace. My house does abut up against the golf course. Right now, I took a picture this morning. The weeds are past my knees. And I have friends in town. We sat out on the patio last night and played cards. And I heard critters I have never heard scurrying and tweeting. There's things living in there now. And so just my input is, it's very unsightly. And we bought on a golf course.
I understand.
Okay.
If it's wet, it could be good for fireflies too. Small
I have not
consolation if you
seen
got
yet.
critters. Okay. All right, I appreciate your input. Thank
Okay,
you.
thank you.
Is there anyone else who wants to be heard on this case?
Good morning. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Please state your name.
James Peters.
Thank you.
I live at 920, and besides everything everybody else has said, there are two massive trees. One's right, I mean, literally from here to the back of your wall from my house, big oak that has come down. You talk about an eyesore. I actually mow across the street because I got tired of the weeds being waist high. We've had rats come up that we've never had before, all of a sudden. I've seen two, that's all it takes for me. I'm a farm boy, and I don't want that stuff to even get started, because once one's there, you have many others. The weeds themselves is one eyesore, but also the pond that's there, none of that's being irrigated, and it's hatching out more mosquitoes than normal. That's right off my front door again, too. But there is not a lot. They were in there and mowed one time, and they didn't mow the whole thing. They mowed bits and pieces here and there. But the owner is not taking care of the place, as everybody stated.
Okay.
I just wanted to get that part in about the trees, too.
Okay, thank you.
All right, thank you.
I have two questions. One is, how big is this property?
155 acres.
Okay, so I see a violation address of 4543 East Windmill Drive, but that's actually the
It's the
address for
entire-
100 something
yes, sir.
acres? Okay. That helps give me some insight. In other words, it's not just a quarter acre that we're talking about keeping mowed, it's
No,
a
sir.
substantial property.
Yes, sir.
Second, does anyone know the password to the Wi-Fi here? Does anyone know? I mean, what's the network? I'm curious. Okay.
They can have
Okay, if someone could just write it down for me, I'd appreciate it. Sometimes. Citrus County? Just one word? Yes. All lowercase? Yes. And any of the, like there's BOCC networks? Okay, all right, thank you. Sometimes I do a little bit of background, research. Is there anyone else from the public who wants to be heard on this case? I thought I saw other hands. Okay.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Your name, please?
Robert Stout.
Thank you.
Good morning.
Good morning.
So I reside at 1204 North Timaquan Trail in the neighborhood. And even leaving this morning, the weeds and the grass on the course are definitely above knee high. This adversely affects our property values. We all bought into this community because of the golf course. But also repeating some of what was said, that, the structures are now in decline, which is causing issue with vagrants coming into the community. And the rodents and whatnot as well. That's, we're seeing more and more of that.
All right, well, I appreciate that. Is there anything else?
Nope, that's it.
Okay.
Thank you.
Thanks, sir. Are there any others who want to be heard? Mr. Darmiento.
Well, my name is Joseph, and I'm in the community.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Please state your name.
Joseph Darmiento. I own a business, Joey's Junk and Debris. And if y'all have a problem, give me a call, and I'll clean it up, or maybe take my phone number, give it to the man that owns it. I'll demolish the buildings or mow the grass, whatever you need at a cut rate. Make it look beautiful.
Thank you, sir. I appreciate that. There's been this idea over the years that businesses aren't public services, but I think we've just heard about how that can be a public service. All right, very good. Is there anyone else from the public who wants to be heard or to advertise? Sir?
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Please state your name.
Todd Peters.
Thank you.
I just moved down here and I noticed that our taxes, if you live on the golf course, you pay more tax. I'm wondering if now it's not going to be a golf course no more, I'm going to get a decrease in taxes. And this is for the property appraiser.
Okay, all right. That is a question for the property appraiser, and good luck. Is there anyone else from the public who wants to be heard on this? Okay. Sir, you know, at these hearings, it can be sometimes difficult to stand and listen. Of course, you're a professional, but is there anything that you want to say in response or otherwise?
Sure. So Brass Boys Enterprises, of course, is the owner of this property. The golf course had to close in late April. It was quite difficult for them to manage everything at the time. They've got a lot of properties around. This, as we said, is about 160 acres of property that has to be mowed. I was advised that they're in the process of doing that this week. I believe some of it has been mowed, but of course that's not going to reflect everywhere. Especially I've looked at the property, there's people that live right alongside it. So I can certainly appreciate the frustration that that causes. I grew up in the country as well. I know what happens when you get a lot of tall grass. However, within 60 days, the property can be mowed, and our client is also looking for a hay contractor to hay the property regularly to also help keep it maintained. I drafted a contract, so he believes that should happen within the next couple months as well.
That's good news. In order to kind of figure this one out from my perspective, just you guys have come to your own agreement, but I'd like to see the photos if
Absolutely.
I can.
Yes, sir.
You know, please share them, you know, and let me know if there's any objection, Mr. White, but just let me know. And so you understand, Ms. Wright, normally on like a small quarter-acre type case with a violation like this, I'll grant 7 to 14 days. So that's why I was curious about the size.
Most recent ones are in the back.
Okay.
Yeah.
Are these all from May? Some from June?
Yeah,
Okay.
May 27th.
We got some
They're all
June.
date time stamped.
Okay. It's just yesterday. Thank you.
I just want to take a look. That's okay. I don't really care. Thank you. Just want to have an idea of what we're talking about on the property. Is this just an overgrown, like, you know, vegetation case?
This case is, yes, sir.
Do you have any accumulations of?
There's a down tree you can see in one of the photos that I could access. I'm not sure about the rest of the property.
Mr. White, do you have any objection to these documents just coming into the record?
No, sir.
Okay, then they'll be admitted as Exhibits A and B. I just want to do that so everyone understands what I'm looking at. I guess, why 60 days? I mean, I know it's big, I get it, but, you know, normally it would have been maintained in the past. I mean, how long does it take to mow really 155 acres?
Right. I believe 60 days is just to be safe, and given down trees and other concerns that may have grown up on the property, and taking care of the accumulation of anything. And that's also the amount of time that he would be able to get a landscaper or a hay contractor under contract and have a little more systematic approach to this.
There's a lot of public concern here. You know, it's not every hearing that we get this much input from the public, and that's because it's a big property and could be affecting a lot of different other properties. So y'all have resolved it, and I feel constrained to accept it. But I will say that as part of the order, you know, this is going to be hard and fast. There's no extensions. There's no nothing. Okay. All right. Then I'm going to find that there is a violation on the property. I'll grant the agreed upon amount of time of 60 days to bring it into compliance. But if it's not brought into compliance, it'll be $150 a day, no extensions.
Thank you.
Okay. Thank you. Thanks.
Next two cases, Dorothy Burns, case numbers 2025-833 and 2025-932, Code Officer Cody McGuire, pages 12 and 13 of your agenda.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Your name, please?
Kenneth Burns.
Thank you.
And I was told this was a no contest on both of them, 2 weeks to cure on both of them, and $100 a day thereafter if not cured on both of them.
What was the amount of time?
2 weeks.
2 weeks on each case.
Correct.
And what was the agreed fine amount?
$100 a day.
100 a day. Okay. Sir, welcome. And what is your name?
Kenneth Burns.
Kenneth Burns. And relation to Dorothy Burns?
She was my mother.
Okay. Are you an owner of the property or?
Well, my mother passed, so I kind of.
You're there?
Yes, sir.
Okay. Well, then I find you have standing. Did you hear the resolution that was announced for the record?
Yes, sir.
And you've agreed to that?
Yes.
Okay. Then what I need to do is ask, is there anyone from the public who wants to be heard on either of these cases? I don't see anyone. Let me just look through the cases we have. So it's a junk case and a discarded vehicle type case?
Yes, sir.
Okay. Okay, then what I'll do is in each case, 25-932, 25-833, I'll find that a violation exists, and in each case, grant 2 weeks or 14 days to bring the property into compliance. To the extent it's not brought into compliance on either one, there'll be a $100 a day fine. Okay? Good luck.
Thank you.
Next two cases, Jeremy S. and Desiree D. Lewis, case numbers 2025-1031 and 2025-1058. Code Officer Erica Olson, pages 25 and 26 of your agenda. For case 1058, experts on the case, Joanna Catu, and Building Division's Morgan Spencer.
Your Honor, I've been notified we have a no contest on both of these. On the junk and debris case, which is 25-1031, 3 weeks to cure and $100 a day. On 25-1058, the LDC violation, 90 days to cure and $150 a day thereafter.
Okay, sir, what is your name?
Jeremy Lewis.
Mr. Lewis, did you hear the resolution announced on the record in both of these cases?
Yeah.
Do you agree with that?
I mean, if I, on the, she says.
Oh, I'm sorry.
Oh.
I thought you were sworn in, please.
Yes, I do.
You don't agree with the resolutions as
yeah,
announced?
I just, for the time frame on the junk and debris, if, you know, I was asking for 30 days, but she started at 7, but I'm leaving for town.
Hey, that's the way that things are negotiated, you know, right? I mean, it sounds like they can't, well, maybe they're aware of the kind of concerns I might have. You know, you haven't seen me today reject any of these. I came very close on the last one to rejecting it based on public input. But sometimes what happens is I look at the junk and I might be very concerned by the junk, you know. I haven't seen any photos here. So if I do look at the photos, I may then go, it should be 7 days. So, I mean, that's the risk.
Yeah, I mean, she knows. She came out the other day. I mean, I've made a huge cleanup on it.
In other words, you've improved.
Oh, yeah, I've definitely. I mean, I worked on it for a week getting everything cleaned up. I mean, really what's sitting there now is split firewood that's in a trailer and some of it's on the ground.
It sounds like 3 weeks would be enough for that.
Just hoping to have a CO and move into the house within the next 30 days. and then I don't have to worry about moving the firewood, but
Well, let me know, do you have a resolution or not? Because if not, I'll go through the case and I'll just make whatever ruling I make.
as far as what do we agree upon, 15 days or something? 3 weeks? Yeah, that's fine.
Okay. Is there anyone from the public who wants to be heard on either of these cases? I'm trying to decide if I should look at the photos now. Are you sure? I'm not trying to twist your arm into a resolution. You have rights, you can be heard. Maybe you get more time from me, maybe you get less. Let me know what you want to do.
The 3 weeks is fine.
Okay. All right. Anything else that the county wants to put on the record?
No, sir.
Looks like a no. All right, in case number 25-1058, I'll find that a violation exists, grant 90 days to bring it into compliance. If it's not brought into compliance in 90 days, it'll be a $150 a day fine. I presume this is related to the permit and the CO.
Yeah, well, I pulled a permit to build a barnuminium and then got the price to do the build out, and I was like, well, hell, we might as well just put a mobile home up. So now the barnuminium is just turning into an accessory building. And
the barnuminiums are a lot more expensive than people
they
thought.
wanted $200,000 to do the build out. I was like, well, we could put a mobile home up for that.
I hear you. And then in case number 25-1031, the resolution I'm going to find is that there is a violation on the property. I'll grant 21 days to bring the property into compliance, and it'll be $100 a day if not brought into compliance within the 3 weeks. And this is the junk case. Okay, so there you go. That's it.
Cool.
You're done.
All right,
Thank you.
thanks.
Next two cases, Cody Victor Swinson, case number 2025-719, and case number 2025-742, Code Officer Erica Olson, pages 36 and 37 of your agenda. Expert for both cases, Land Development Director Joanna Coutu.
Your Honor, on these cases regarding 25-742, which is the violation of LDC 3150 regarding fences, we have a no contest, 7 days to cure with $100 a day thereafter for the fine. The other one is contested.
Okay. All right, and then let me just look at the other case. All right, then let's knock.
We're not agreeing on the time frame though.
Okay, so you're not contesting that there's a violation, but you're not in agreement on how much time.
So this is a very...
Oh, let's do that.
Yes, ma'am.
And before we even get into that, I want to know, is there anyone from the public who is going to be heard on either of these cases? Because what I'm going to do is I'm going to knock one out that you appear to have an agreement on, and that's the fence case,
I've
right?
already got the barbed wire down.
All right.
I took it down yesterday.
So this is case number 25-742. The resolution is that there is a violation, but 7 days to bring it into compliance, $100 a day. If not brought into compliance, not going to be a problem for you, but that's going to be the resolution. That's what my order is going to say, okay? All right, so let's set that case to the side, and let's only talk about case number 25-719. And again, it sounds like there's no contest as to whether or not the violation exists. So, Ms. Olson, would you mind if I just spoke directly to the respondent first? Okay, what's going on?
So I have applied, I did a water retention area, and also apparently I need to get a permit for the track that I built for my kids too. I have 10-acre property over in Floral City. Didn't know I needed the permits for those things because when I bought the property almost 2 years ago, I bought it under the ag flag. The property appraiser misrepresents what the zoning is on these properties because I would have never bought it if it wasn't agricultural zoning. I would have never been able to get the loan. So it also tricked the people that, that I got the loan from. But the property appraiser, when they reclassify an ag flag, they actually change the zoning classification on their website, which misleads people to purchase properties that aren't actually zoned ag. On top of that, the property that I purchased should have never even had an ag flag because the owner's been dead for 20 years and it sat vacant for 10 years. And that's what's kind of brought this whole situation up. Had I had the correct classification of an ag flag like I thought I did, none of this stuff would be a violation.
Well, okay, then let me turn to the county. that's news to me. I mean, I don't think that's true with most of this stuff. So what is the county's case?
So it's a violation of Land Development Code 4100 site improvement plans. Do you want me to go through the?
Well, on my agenda, it says 4002A.
Yes, I'm sorry.
Okay. And so that's the one where basically the county says, look, you really can't do any development on a piece of property unless you get our approval, but, you know, whatever the method, site improvement plan, whatever. But that's the issue. So my understanding is there may be a few exemptions under Florida statutes, very limited for very specific agricultural things. But that's why I'm trying to find out, what is the county saying happened
I'm actually
here?
going to direct this to the Land Development Director.
Okay.
I think she can give you a better understanding.
Okay.
So the zoning is rural residential mobile homes allowed. It's not ag, it's not been ag, but they did have, the previous owner had an ag classification since 2013 for grazing. It was removed in 2025.
In other words, it had an exemption. It had
It actually is agricultural classification, but exactly what you're talking about. It's the
Correct.
exemption through the property appraiser
Correct.
for grazing. It was
Right.
removed in 2025. It's
Okay.
no longer in place. So the zoning didn't change, but the ag classification was removed by the property appraiser. So it's still the RURMH.
Right. Excuse me, sir. Well, hold on a second. Thanks. And what is the county saying actually was done on the property that is violating? Like, what was done on the property from the county's perspective? And then I want to hear from.
So there is a pond that was put in without permit.
The
and
water
then
retention area he talked about?
Yes. And then there's also like a dirt bike track with hills and jumps that was put in.
Sounds very reasonable use of a 10-acre property.
My kids love it.
I think I'm jealous. I didn't have that growing up, but all right. So, but it's hard to imagine the basis for why the track would have been, even if it was agricultural.
To be perfectly honest, I had no idea I needed a permit for that.
Gotcha.
There's no
Gotcha.
contest.
Fair
I'll
enough.
get it.
Yeah.
Yeah.
A lot of people are surprised by that. You know, it's not the first time I've heard that at a hearing
And I
like this.
have the conditional approval for the water retention area, because there's another case that I have where I didn't permit the 2 tiny homes I put on there, and they're saying that I can't, it's an accessory structure is what they're saying. So I can't put an accessory structure before a principal structure.
Correct.
There's a mobile home there that is the principal structure that I got issued the permit yesterday to demo that.
Okay.
So conditional approval, as soon as I apply for the residential permits.
For the pond.
For the pond, yeah.
Yeah. Okay. Well, from the county's perspective, what would it take to bring this into compliance?
He's going to have to get the required permits for the pond and the dirt track.
Okay.
But he's going to have to get the
So for
primary
both of
use.
those, he needs to have the primary use. And is it sufficient to receive the permit, or does he have to have that finalized?
He would have to have that finalized, I believe. Right?
I don't.
He needs the principal structure established. I'm sorry. He needs to establish the principal structure first, which we don't have a permit for yet. And then he can do the dirt track and the stormwater.
But, you know, is it sufficient to receive the permit?
I would say as long as the permit is kept active, that he's addressing it, yeah. We would.
Okay.
And
Okay.
they'll see that I'm all active.
Well, now we're on the same page. So how much time do you need to get a permit?
So the issue with the residential permitting is it's gonna cost me in excess of like $15,000 between the engineer, the repairs I have to do to make sure that it's code and everything else, which I'm willing to do. However, I'm in a hard time right now and I don't have the money to do that. I'm struggling to even put food on the table right now for my kids. The last 3 months has been hard for me. I gotta fork up $5,600 today to even get the permit submitted.
Right.
That's where the issue lies, is I don't have that money. I'm having to go out of town right now to go work with my brother in Tennessee to get some work. Yeah, I mean, I don't want to give you a sob story. I'm just,
if it's
a tough
relevant,
time right now.
if it's relevant to the time, then I should know it. But you know, my question still stands. How much time?
Well, it's already handled. I mean, here's the water retention. It's conditional approval. If you want to see this.
No. So what I'm saying is,
For the
in order
residential.
to resolve the case, you either have to get rid of the things that you've already done, which seems like an even greater hardship, or you need to get the permit to establish the primary use or the primary structure.
Absolutely.
So how much time do you need to get the permit?
I'm gonna be honest with you, I don't know when I'm gonna have extra money, so I want you to know that I'm actively working on it, but I need as much time as possible.
Okay.
I have pretty steep bills, and my wife's had COVID the last month, she's been out of work, and it's just.
All right, then let's go through the exhibits. So I'd like, if possible, to show the exhibits to respondent. And sir, I'd like to ask you to look through them and just let me know if you have any objection to them being evidence.
Another thing that I'd like to note.
No, I want everything. Yeah, thank you.
Another thing that I'd like to note is that I didn't get all these until she posted on my property.
Okay, we'll talk about that. I
Okay.
want to know if you have a legal objection. So I construe that as, okay, I didn't get this. Let's talk about that. But do you have any objection to these documents being evidence? Do you think they're inauthentic for any reason?
Well, there's an associated address here that has nothing to do with me.
Okay, I mean.
Listed as the title on.
Okay, well then it's not going to be evidence. I mean, that's okay. What do you have for this case, Ms. Olson?
I have the notice of hearing. Sorry.
You're good. Yeah.
Take the pictures?
Yep.
I have basically I have everything except the notice of violation. I turned off the wrong notice.
Okay, so let's go through what you've got. So number one is, yep, there you go.
And I've seen these because I picked them up from her.
I'm not really concerned with whether or not there's notice because you're here. In other words, it's not unknown at this point. But I do want to know when you first learned about the violation.
July, it was like the very beginning of July, I think, wasn't it? Like
Okay.
July.
All right.
And the thing that frustrated me is I had notices that once I met with her, I got the notices and they were dated back to the beginning of March. So
Right.
how many months had gone by that I lost my rights to appeal?
0.
Oh, really?
Yeah, nothing's been determined. I haven't determined anything.
Okay.
There's no basis for an appeal.
That's
Until
why-
I rule, you know.
See,
so
that's why I'm not an attorney.
No.
so.
That means you have common sense, unlike most attorneys. But still, I think, no offense to the county attorneys. Yeah, look through these photos and let me know if you have objections to them.
No, like I said, I'll get the permits for the stuff. I didn't know I needed it for the track, so that's no problem. And I'll go home and apply for that permit today.
All right,
no
let's
problem.
take a look. I would like to see these. Thanks. Okay, so yeah, I mean, I think the documents match up. There was a postponement of the hearing, so this was originally going to be heard in July?
Yes.
Okay.
And then we talked. He came in, we talked, and he requested more time.
Okay, all right. And then looking through the photos, just so I have some understanding.
It's hard to see until you get to the aerials.
Which I'm curious, how are those aerials obtained?
Talk to the property appraiser about that. Let's see. Although, just so you know, you'll be interested if you do look at the property appraiser. They've been doing it for decades. So I'm just thinking about this.
The issue is that they're tying this issue into the other issue of me needing to apply for the permits for the residential, for the principal structure.
It's not them. That's what the law says.
Well, right. And I understand, and I'm gonna comply. but
Yeah.
I just need the time to do it, that's all.
Yeah, and that's what I'm thinking about. So I'm thinking about the amount of time that's reasonable, thinking about other cases with similar facts and situations. It's very rare that anyone comes in and says, oh, this is easy for me to spend $15,000 or $5,000. It is usually always the case that it is a hardship. And yeah, there's been some work already done on the property. You know, doesn't look bad.
No, I keep the property.
Yeah, I mean, but I think it took time. I think it took money.
It's a big property.
It's a big property. It's not costless to maintain.
Takes me about 6 hours to mow it alone.
So normally on a case like this, what are you going to establish? What's the principal use? What's the structure?
It's just 2 homes that I put there.
You don't have the homes?
No, they're 2 tiny homes that I put there without permits. So that's what they're wanting me to permit, is to get those started.
You don't have engineering for them or anything?
No, I don't have anything. I have the engineered plans because it was one of those tiny sheds that I bought, you know, so that I have like the engineered plans from them, but I talked to local engineering in Floral City and they're like $5,600 for the plans, and I need those plans to even submit the first time for the permits.
So they didn't come with plans?
They came with plans, but they have to alter everything and I guess put it into like the actual site plan and you know, I guess there's more to it based on what they said. And I talked to 2 other engineers also, and they were even more expensive than them, so that was kind of difficult to deal with there. It's just hard for me to sit here and say like, oh, in 3 months I'll have the money, or 6 months I'll have the money. Like my wife's out of work right now. I'm having to go out of town to Tennessee to get work. You know, it's just rough.
Is there anyone from the public who wants to be heard on these cases, or this case, I should say? All right, what's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $150 per day in addition to administrative costs to begin after the date you deem sufficient.
Are there any immediate health, safety, sanitary concerns with what's been done already?
I do not have any, nor have I heard of any.
Okay. It's not Christmas, but this is the max I'm ever willing to go, and I'll grant 6 months. If it's not brought into compliance in 6 months, $150 a day.
Okay, now question, what is compliance exactly?
Getting a permit for your principal use.
Okay, now, is that applying for the permit?
No,
Because,
it's receiving the permit.
okay, well, now this is where the issue is gonna come in. Because sometimes it takes 3 to 6 months to get building permits like this issued.
Yes.
So
That's why you have 6 months.
So I would have
Your alternative is to remove. I mean, you can remove all these things.
Which you
but
said yourself sounds like a bigger task.
I think so. That's why I'm giving you 6 months.
Okay, that includes the sweet time that the county decides to take. It took me 3 weeks to get a demolition permit for the mobile.
Sir, I can change it. I can give you less time. I can increase the fine. This is the most time that I give for this type of a thing. And the reason is you created the violation, not the county.
Correct.
No one else in this room created the violation. You could have gotten the permits, you didn't. Everything that's required to be done in this county, you have to go through this folder and that folder and do 10 things, but that's the obligation. So
I don't disagree with you.
So what I'm doing is I'm saying I'm not gonna do 7 days, I'm not gonna do 30 days, which you would get in Orange County. I'm not gonna give 14 days, which you get in Lake County. I'm gonna give you 6 months. And there's a lot of different options that you have to fix it. You could remove not just the offending improvements, you could do a different principal use besides the tiny homes that comes with the engineering. You could do a lot of different methods. I'm really confused as to why this isn't, for you, a win. As tough as it is.
I have no objection other than I could apply today. The permit may not be issued in 6 months, so what happens at that point?
Well, what you should do is if you have concerns or if you think it's the county's fault or something like that, you can always ask for an extension.
Okay.
But you need to hustle. So that's
Well,
what the order.
I have no problem doing that.
Okay,
but
that's the order.
The county needs to hustle also, because that's the issue.
This hearing's over. Thank you.
Thank you.
on the day's agenda, John and James D. Darmiento.
What about Shadow? I have one more no contest. Shadow Court LLC, page 32.
Shadow
Court LLC,
Okay.
page 32.
Hey.
Wait, I guess. Hold on.
Yeah, I have it as a no contest. Where'd
Yep.
Erica
Yeah.
go? Oh, okay.
Next case, Shadow Court LLC, case number 2025-892, Code Officer Erica Olson, page 32 of your agenda, expert on the case, Land Development Director Joanna Coutu.
I've been notified that this is a no contest case, that the parties have agreed to 2 weeks to cure and $100 a day thereafter.
Okay, sir, what is your name?
Alfredo Felice.
Are you sworn in? All right.
I do.
Mr. Felice, are you an owner or representative of Shadow Court LLC?
Property manager, yes.
Okay. And you heard the resolution, basically 14 days. If it's not brought in compliance in 14 days, $100 a day. Does that sound right to you?
Yeah, I just found out about this, yeah.
Okay. What is the issue, by the way?
There was some mobile homes on the property. No one was allowed to be there. It was 2 separate folios. They were there, all hooked up before, the electric there. I had to meet, as soon as I get the letter, they were all 4 removed. I had 2 homeless veterans I let stay in one, so I had to help them get out. And there's one there, and it's being removed by advanced towing today.
Okay.
So I'll be
All
way
right.
before the 2 weeks.
That makes sense.
Yeah.
Is there anyone from the public who wants to be heard on this case? Nope. All right, then I will accept the resolution, find the property in violation, grant 14 days to bring it into compliance, $100 a day if not.
Yep.
Thank you.
All right, thank you.
All right, now we're done with the movie trailers, and we can get on to the main show.
Okay. Sorry about that, Mr. Darmientos.
Next case, John and James D. Darmiento, case number 2025-1073, Code Officer Erica Olson, page 15 of your agenda, expert on the case, Land Development Director Joanna Coutu.
Sir? I've already sworn you in. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Please state your name.
My name is John Darmiento.
If you would, sir. Just for the record.
Joseph Darmiento.
Thank you. Welcome, Ms. Olson.
Thank you. This is case number CE 2025-01073, special requirements for all accessory structures, a violation of the Citrus County Land Development Code 3102 Alpha. The address is 5973 South Ashlawn Way, Homosassa, Florida. This is a vacant property, 0.49 acres, zone MDR. Property owners are John and James D. Darmiento. I have good service via posting on the property and posting at the Lecanto Government Building. At this time, I would like to authenticate the following documents and request that they be admitted into evidence.
Can you give me a narrative of what the county's case is on this?
Yes, sir. This is a vacant property, and there is a old school bus and 2 halves of a mobile home that have not been installed, placed on the property.
There's a school bus and 2 halves of a mobile home. Like
Yes.
it's
It's
split
a
in
mobile
half.
home that hasn't been installed, so it's in 2 pieces.
Oh, okay, gotcha. And what is it zoned?
MDR.
Not MH, right?
Yeah, not MH, yes.
Okay. All right, so you've got some exhibits?
Yes, sir. Exhibit A are the photos taken during my initial inspection on the 3rd of July, photos taken during my compliance inspection on the 21st of July, and photos taken during my final inspection conducted on the 18th of August of this year. Exhibit B is a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, a copy of the notice of hearing posted on the property on the 8th of August, and a copy of the posting affidavit.
Okay, so, sirs, y'all know the routine. Normally I'd ask you to just look through these documents and let me know if you have any objections to them. But my first question is, are you contesting whether there's a violation or not?
I'm really not sure on that, but I did not get any notices until I had to go to the post office and sign for it, and that was only like a week or so ago.
Okay. Well, I mean, just so you know, my understanding of Florida law is that that's sufficient notice, because this isn't like a regular court hearing. This is a quasi-judicial
Well,
not
there
really a
was
judge.
no notice given other than what they sent in the mail.
I
A week
understand.
ago, I didn't get
I
till
understand.
a week ago, so.
Well, I understand that. But what I'm saying is, even if you had found out yesterday, that's pretty much sufficient law because you're here, if that makes sense. So I get what you're saying, but this is a violation of 3102A. So what exactly is the violation? Like, what have they done wrong?
It's storage on a vacant.
Okay, so there's no principal use established,
Correct.
and there's stuff there.
Yes.
Are y'all contesting?
Well, yes, because it's a mobile home that we were bringing to put on the property, and then later we find out a mobile home can't go there. It has to be a modular home. So we already had the mobile home there, and now we have to go through permitting, which then we just found all this out.
So we need a variation, some other things.
Well, sounds like you need a rezoning.
A rezoning.
Or
a variance.
Or get rid of
I don't think a variance gets you out of this. Is there a variance? No. So wouldn't be a variance. Theoretically, maybe a rezoning for the mobile home. Maybe you could also take the stuff off the property.
Well, that'd be
get rid of the violation.
All right, but I got one question. If we go to rezoning, do we go in front of you, or do we need some special?
Oh, not me.
No.
Not me. That's the county. The big.
And do we
the big
need
boys.
some special information, like to be like why it should be rezoned, or like is it just?
Well, you'd have to talk to the county about that. And of course, I always encourage you to hire legal counsel to do the rezoning. But they can always say no. There's a lot of different. I have no idea what they would do. I'm just telling you, if you want a mobile home, that doesn't sound like there's a mobile home allowed on this property. Period.
Well, yes, you're correct. But let me just where we came from. We owned a property across the street that was a mobile home. There's 5 mobile homes all up and down every which way on the road.
I'm not contesting. You probably had good reasons, but you're here.
Yes, and that's all I wanted.
So that's what I want to know. Are you really arguing that there isn't a violation?
We're in violation.
Then I just want to know how much time y'all need to fix it.
We would like to get 6 months to try to, because they said 6 to 8 months, but 6 months.
This is my fault. I started giving 6 months because I heard one. So this is my fault. Well, guys, look, let me talk to the county for a second. What is allowed on this property? Like a modular home, is a modular home allowed?
A modular home is allowed, or a house, but a mobile home is not permitted on that side of the street. It's not zoned for it.
Nor are they allowed to live in the bus.
Correct. So, right now, nothing can be on the property because there's no principal use established.
Have y'all ever heard of a rezoning to a zoning that
question
would
for the
allow?
land development
I mean, if
director.
it's true, what they're saying, that there's a lot of surrounding properties that do have mobile homes.
It happens. It's a couple $1,000s. I don't think they realize that because of the hearings. It's unlikely because it's a code case that that's a special permission kind of thing because after the fact.
Because there's
We have no permit applications for the mobile home itself anyway that we could have denied. It just showed up, so.
Yeah.
However, I did talk to rezoning, and they told me that for a fee, they could put it before the zoning board.
Yeah.
And it can or cannot, it's up to them if they're gonna change it, not up to.
I agree.
code
I mean, I
enforcement.
agree with that. But what she's saying is, and I think this is true, they're less likely to do things when there's a pending code case. In other words, they're usually willing to be pretty.
Well, as far as the mobile home goes, it's there and ready to be set up, but you can get an after-the-fact permit for that.
And they said we could change it into a modular home. There's just things that you have to.
You can change the mobile home into a modular?
That's what they told us at zoning. You just have to get special engineering to change it into a whatever the difference is from mobile and modular.
Right, so they want you to put in a foundation so that it can't be moved and take the wheels off and set it on that.
Is there anyone for the public who wants to be heard on this case? Okay. Well, first of all, what is the county's recommendation? I'm just curious.
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $150 a day in addition to administrative costs to begin after the date appropriate to allow the respondent adequate opportunity to abate the violation.
You know, when I was a prosecutor back in misdemeanors, we would very often have people who you almost rooted for, like, man, they almost got away with that one, and they probably got away with a lot of misdemeanors. And There was one I remember who I considered a genuine misdemeanor mastermind. But eventually he graduated to felonies and became a real danger to the public. You guys are not like that. You know, I've seen you on several different violations. The thing I'm confused about is why y'all don't do this ahead of time after all these years.
Because they're like pit bulls. Once they get a hold of you, they won't let go. Every property we go to try and make some money or do something with, they're there.
It sounds
They
like
say,
someone's
"Oh, it ain't
complaining."
us. Somebody called." But just
I can go through other
recently,
facts, and
you
I
know,
can prove that no one's calling on some of these things. The lady even was begging for the homeowner, where I have some of my stuff, to press charges on me. It wasn't about cleaning up the mess. She was begging this man. Every time she talked to him 5 times, the man said, "I don't know what you did to this lady, but every time I talk to her, she's begging to get me to press charges on you." And I'm
trying to put me in jail at my age, just for stuff that should be cleaned up.
My
She
gate's
drives
open.
by our house.
Do you want to speak, Mr. Charlton?
Yes, I was out at the property during an inspection with Code Officer Erica Olson, and there was a complainant that came across the street to us, again, to us, while we were doing an inspection, and stated to, you know, there's people, homeless people going into those mobile homes there on the property and getting
Can
into
you
the
get sworn
bus.
in,
But
Mr.
that's
Charlton?
not
sorry.
true.
Yeah, well, let's just get you sworn in.
Hold on, I got something. Mobile home has nothing to do with it.
Is everything you just said true and accurate to the best of your ability?
Yes,
All
sir.
right, please proceed.
Yes, sir, and the violations, they come in from complaints, and we continue to get a high volume of calls for these complaints, and so no one's targeting or harassing or anything.
Well, and Mr. Darmen, here's why I'm bringing it up. I think there are complaints. It makes sense because sometimes when I get the photos, I'll see that I can understand it, you know? So I guess I'm just wondering, why not try to bring it into compliance, you know, work with them ahead of time?
I didn't know that there was you couldn't do that. You know what I mean? I thought
Well, that's
I
what I'm
could bring
saying.
the mobile home
Really,
there
we're at the point where anytime you are doing anything on a piece of property, you should call them and be like, look,
Can I
I'm
do
thinking
this?
of planting a rose garden here. Is this okay under the, I mean, I'm just saying.
I
and-
agree.
Well,
You're 100% right.
it's-
Even a rose garden.
But
should
y'all
be
are
called.
doing more. I mean, I'm not saying it's like you have these, I admire it, frankly, schemes. You know, you've got a mobile home going in and there's a school bus on the property. God knows what you're doing. I have no idea, but it sounds interesting. But I can't ratify it.
We're just trying to
make
set
a
up a
dollar,
house.
set up a
That's
house
all.
to make a living.
Well, that's why I'm not going to give 6 months because this is like the 8th, 9th time. I can't justify it to all the other people who, you know, once or twice. I will give you 3 months. And so within 3 months, this has to be fixed, okay? Or there will be I don't even remember, $150 fine
Yes, sir.
a day? That's it.
Understood.
And I know
Fine.
y'all will fix it.
Yes, sir.
Because you always find a way.
And we're here for another violation too. There's another case.
Not another one.
Yeah, because she's going by her house taking pictures of her gate being open, and you know.
It might be on a different day, but it's not today. This is the only one we have today.
I do see the Darmen on case number
It's under
25-1092, actually. So,
I'm gonna call that
okay,
case
you're
next.
gonna call that next? Guys, if you would, let's let Mr. Charlton.
Next case on the agenda, Margaret Schultz, James David Darmiento, Corona Darmiento, and James Raymond Joseph M. Corona. Case number 2025-1092, Code Officer Erica Olson, page 31 of your agenda.
Okay, I see it. So no sooner do the words leave my mouth about the 8th or 9th, you know? But I'm rooting for you. Go ahead.
This is a repeat violation initially observed on the 3rd of June, 2025. The address for this violation is 3625 South Alabama Avenue, Homosassa, Florida. These property owners were previously found guilty of the same violation at the same location on the 20th of October, 2021. That's case number 213-1685 with $0 in fines. And again, on the 18th of October of 2023, case number CE 2023-00808 with $3,228.63 in fines.
I think that's wrong. I think he's charging me more, but
It was 5,000, but Anyway,
Well, let's, hold on a second. So,
Yeah,
please proceed. What's going on here?
This is for accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20, TAC 31 Alpha of the Citrus County Code of Ordinances. This is .29 acres zoned MDR MH. Property owner Margaret Schultz, James David Corona Darmiento, Raymond James Corona, and Joseph M. Corona Darmiento. I have good service via posting on the property and posting at the Lecanto Government Building.
Okay, and I presume that you have photos and,
Yes.
all right, so before we get into that, let me just, you raised the concern about seeing Miss Olson like every day taking photos and that kind of, let me just tell you, I've had the same question in the past, because we used to have a code enforcement, maybe you met her, Amy Becker, and she would take photos like every day of the quote-unquote repeats, the reason being that maybe on one of those days you might come into compliance and then she's not going to hold you responsible for those days. So they constantly do it to see, is it in compliance today? Is it not in compliance? I had the exact same question because it seemed like a lot to me. And I think that's a great answer. So is that the reason why you're taking photos as often as you are?
Yes.
Okay. So I'm going to set that to the side. And now I want to hear from y'all before we get into photos. What's going on?
Okay, I'll knock that right down there because we were already cleared in compliance at that time. When she's going by our house, she's in the passenger seat. My dad's bringing groceries through a fence. Now, when we were
She slows down to get to the point of where she can take the picture on an angle through the gate.
Yeah.
But that's beside the point. Let me speak. Wait.
Please, real quick.
They also want us to take the cars that, like, we drive and we park to the front of our house on the easement of the street. In the county of Florida, in the Citrus County, under the code, you're allowed to park your vehicle in front of your house on an easement as long as it's not designated something else. No fire hydrants, no parking signs, no nothing. So now we can't park nowhere in the front or the side of our house in any way, shape, or form on the easement. That's what she said. Another day, she noticed that I have a wood mill. She said, well, I'll just see if I'll let you have that. I mean, I don't understand who they think they are, that they could decide whether I can have something or not have something, or where I can park my car, or when I can park my car.
I don't know
It's
about
just
the
getting
easement, but I will
ridiculous.
tell you, it's their job, and it's not an enviable job, to make sure that you follow all the rules here. Whether anyone likes it or
The
not, that's
state
their
law-
job.
Wait, let me speak. The state law says, and you could look it up, that you are allowed to park on the easement in front of your house.
Is that a part of this case?
No, it's
Okay.
not. There
She
is a,
absolutely told
All
us
right,
that we
then let's
cannot park our
go.
vehicles
Let's go
there.
through this by the book.
Yeah,
Let's
let
go
me
through this.
speak.
Go ahead. What do you want to
Okay,
say?
She came because there was vehicles on the easement. This is what started the case. She tagged all the vehicles on the easement because my gate was open.
Microphone. I just want to make sure you're picked up.
Because my gate was open, which was the old fence. They told me to put a fence around my property and I could put whatever I want in my backyard behind my wooden fence. That's what I did. That abated and made me clear. I paid the fine. I ain't been in trouble in years, okay, because I put the fence up. So she said because she came and them cars were parked on the easement and she tagged them, she seen my gate was cracked open so she could take pictures behind my gate where I go in and out and bring my groceries in and out.
Okay.
Okay. And this lady literally, after I abated and shut my gate and cleaned up called him, he said, it's good to go, you shut your gate. Okay. She's still coming by after it's done and it's clear and they know it's clear and she's in the passenger seat. I said, Dad, we're carrying in groceries. I said, shut the gate because I see her go by. And as she's going by, I'm standing on my porch. She goes, dang it, because she couldn't get the picture of my gate open. I literally see her in the car go, dang it, like that, because she couldn't take the picture. I had my dad shut my gate.
These are strong accusations, Miss
this is
Olson.
real
And-
This is very true, sir.
No, I know, and you'll just please forgive, this is very serious. It's relayed as if it's a cartoon, and it's like, God, dag nabbit, these
Exactly.
rascals. And
it all started from the cars that are allowed to be parked on this thing, and then she's making that into a reason.
She red tagged a 2023
I do want to.
brand new
I'm
truck
with you. I'm with
parked
you
on
on.
the front of our house.
I understand where you're coming from, but now I want to take a step back, and I want to do this by the book, and I should have done it in the beginning. Ms. Olson, I think you have some exhibits, and I want you guys to look through them. Let me know if they're okay to be evidence in this case or not, and then I'll get to look at them. All right?
do you want me to go through the whole spiel about the exhibits, or do you just?
Not just show them.
Okay.
I mean, yeah.
Okay.
Documents sent and your previous findings of fact from your previous.
All right. Now take your time and let me know if you have any objections to them being evidence.
I see, that's the gate is all it is. It's the gate is open. I'm allowed to have my gate open. I have a fence
No, you
around
can't have the
everything.
gate open.
Yes, I can. I have everything in my backyard that it's been abated and.
They don't like you as much as I do.
Exactly,
I mean,
sir. It's harassment and it's abuse of their authority. Period. It's my trash cans. I'm allowed to have trash cans and trash.
No,
by
they
the trash.
call the trash people too. They came and told us we have to have cans with lids on them.
Well, I just want to know right now if you have any objection to these documents
Yeah, we
being
sure do.
evidence.
Yes, we do.
Legal objections.
I mean, aerial photos. I mean, I don't think y'all should be harassing, like, you know,
No, that's
getting
probably
into my
pretty
life
good.
that much. But these are all old photos. Most of these with these RVs. And when is this taken? You know, these
Have you
must
sent?
be
you-
different
you
times.
haven't sent the
This is
drones
from
over
last
yet.
year.
Yep.
Unfortunately, we don't
These
have
are all
drones.
old
I wish
photos.
we did.
Most
We
of these
don't.
are old photos
Not
that they're
allowed.
trying to
We're not
make
allowed.
look like.
Per county
Well,
attorney.
guys, I just want to know if you have. So I've heard some concerns about the dates. I've heard some concerns about the angles, and we'll get into that because I can ask her about that.
Yes, sir. No, it's all with.
But these are accurate photos.
Yes, sir.
Yeah,
not,
you're not
faulty photos, not made up.
But even after we were cleared up, after we moved the cars from around the day, she came back.
Well,
Even after
there is a reason for
even
that.
after Mr. Williams came back and said, "Okay, you're good to go."
Well,
okay, but sir, can I
who's
say
Mr.
that,
Williams?
sir? She was complaining
Mr.
about
Charles.
lawn
Okay.
mowers. Lawn mowers, and then she even asked me,
Sir,
well,
just
why
give me
do you
one
have a
second. I gotta
weed
focus.
eater? Why do you have a weed eater in your yard? They want me to clean up, and I can't have lawn mowers or weed eaters. Ridiculous.
Y'all set aside special time
him
for the
talk.
sand mine, but not for the Darmientos? I mean,
I'm-
this
I'll
is.
say, for sure.
I do have something else when it's
Next
my
time,
time
if you
to
would
say.
like,
I'll
we will
tell
set
you
aside
that
some
too.
special time. Just let us know.
Why do you
Okay,
think that tastes
here's
so
what I
good?
want to do.
don't
If
understand.
y'all, sir, direct your comments to me, not to the other
He's
folks.
He's sitting over there staring at me like,
Well, Mr. Charlton, I'll get control of
I mean,
this. So
usually
guys,
we don't have time.
sir, please, you got us.
Please.
I know that we all have a history here, but
Yes, sir.
let me
do
look
it
through these
like an
documents. Let me look through these documents. Let me ask you this first,
Yes,
Ms.
sir.
Olson. So what is, if the fence is closed, is it your position that the stuff behind the fence is okay to be there?
You can still see the stuff through the fence. Like, you can still see that
Well,
there's so
let's say
much
that you
junk
couldn't.
behind
Let's
the fence.
just say as a hypothetical.
If hypothetically, if I can't,
If legally, you cannot hide your stuff behind a fence. The only part of the code that allows you to obscure something from view is a vehicle. That is the only thing that if you put a fence up, it can be obscured by code. By code, your whole property.
Unless it's in a completely enclosed building. So
Correct.
if it's out of view, but it's in an enclosed building like
Correct.
a garage,
Correct.
then it doesn't matter.
Then you can have your garage be whatever you want it. It can look however you want it to be. If it is not in an enclosed building, if it is not in a garbage can with a secured lid, you cannot have your property have.
There
junk
is
and
an
debris.
idea that has, I think, over the years taken hold in Citrus County. And I think that at times there's been different representations that if something is out of sight, it might be out of mind. And I've heard it before.
Correct, and that comes down to evidence for us to present to you. Unfortunately, if it's behind a fence and we can't see it, we don't have the evidence to present to you
Correct.
that they're still in violation. So we have to abate the violation by the nature of what evidence we can prove. We
But
are not allowed
yours-
to send drones up to go up and over. So we have to look at the evidence we can prove. So in this case, we have the evidence that shows the property is not abated. It is continuing to be in violation by having junk and debris on the property, even if it is behind a fence.
Does what she said make sense to you?
no, because you only need three walls. You don't need it enclosed. It just
Well,
has
no,
to
listen,
be,
listen.
has the roof
Let me
and the
read.
sides.
I want to read the code section to you because it sounds like there's some confusion about
Okay,
this.
but can I say something?
Yes, you will, but
All right,
not
yes, sir.
yet.
Yes,
So,
sir.
Wait, let me.
here's what the code section says. All right, it's 20-31A. It is unlawful for the owner or occupant of any land to permit, cause, or have thereon any accumulation of junk, debris, rubbish, and vegetative matter except junk stored in enclosed litter receptacles or completely enclosed buildings. junk which will not sit into a receptacle but is out for no more than 48 hours, recyclable, da-da-da-da-da-da. None of this fence doesn't get you out of any of this because it's not a completely enclosed building and it's not an enclosed litter receptacle.
Violation of privacy. I mean, you can't just go.
Well, that's a constitutional case, but here, you know, they're right. If you can see it, that means they have the evidence to show you've got junk out here that's not in an enclosed building or receptacle.
Okay.
Go ahead.
We've already been through this. We've been cleared and abated. They told us on that date, whenever I was clear last time, you put the fence up, you can have whatever you want behind the fence. Now they're trying to change it into, oh, you can't have it behind the fence. You know what I mean? It's
I don't
wishy-washy with the rules.
Well, look, I've been a special master for years now, and I've always ruled the same way. So I know I've never told you that. Okay, so the issue here is there is a. Are you saying? Well, all right. So unfortunately, I think you are making what's cognizable as a legal defense. There's no doubt that it's illegal. There's no doubt that you will be responsible going forward. The question then becomes, do you have any reason under an argument of equitable estoppel, the idea that the county's told you something in the past, okay, and that you've relied on? And that's a fact question. Are you saying that Mr. Charlton has told you that if you put up a fence that you don't...
I was even cleared when I shut the gate and he came to look at my
When was
property.
this?
Whenever they cleared, Mr. Charlson cleared it over the phone with my father, whenever it was cleared. And
was that on this case?
Yes, on this case, he cleared it. He said the gate's closed, everything back there is fine. Okay.
There really wasn't.
Mr. Charlton, I just want to know, you've already been sworn in. Have you ever told them that as long as something's behind a fence, that they're allowed, it's not a junk violation?
Thank you. No, I have not. I have told them I can't stop anybody from putting up a fence on their property. That does not abate a junk violation. His property failed that day, and I spoke to Senior Darmen on the phone and told him and put a log note in, and Erica, Officer Olson, should have a photo from which I failed that inspection because there was debris on the right side of the property behind a flatbed trailer on a truck. So, and it was in the back of the truck also. I told him because he had an AC unit also. It appeared to be a brand new unit that may have been installed. I didn't have
Guys, you guys listen.
I didn't have an issue with the AC unit on the back of the truck because it was brand new. All the junk and debris behind that flatbed truck is what I explained to Mr. Darmiento on the phone. I told him his case would not be closed.
Okay. Let's
He's lying under oath.
Sir, just hold on a second. All right, so I've asked questions of Mr. Charlton. The correct thing under the law is to allow you to cross-examine if you wish. Do you have any questions for Mr. Charlton? Go ahead.
Let him go first.
Sir, the day you came and you said to me, everything is good. All you got to do is get rid of that cardboard box and whatever's on that truck. I said, that's a brand new air conditioner on the truck that we're putting in the house. He said, okay.
What is your question for Mr. Charlton?
Well, then, didn't you, sir? Didn't you say that day, remove the cardboard box and that little bit of stuff right there and you're good to go?
I told you I could not close the case because it's
You're
a
a liar.
repeat,
You're
but
a
I
flat
failed
out
their
liar.
inspection.
Sir, you asked him a question. Let him answer. This is by the way, this is the last time I'm going to ask that. All right, just please let him answer the question. This is a process, please.
I've already explained everything. I've explained it to him.
I think your mic is off.
I've explained everything on the phone. I explained it to him. It's the same thing every time. They call the office. They try to talk to different people to get a different answer, and then once they don't like it, we get accused of this.
Do you have any other questions for Mr. Charlton?
Yes. Sir, he's in charge, right? Sir, you are in charge of everything? You're the boss of them, right?
Of that division,
And
yes,
you
sir.
that day said to me, she's not working today, blah, 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 and you cleared it. And you said to me, you absolutely said to me, get rid of the box and do something with the thing on the truck, and you're good to go. That's exactly what he said.
I did not clear it. I couldn't clear it because it's a repeat violation. I explained to him that it would have to go to a hearing, and I explained that the fines would not stop that day because he failed it because of the debris behind the flatbed truck. I had no issue with the AC unit on the flatbed truck. It's exactly what I explained.
It's your testimony that you did have a conversation about the material he's talking about.
Correct.
And you had a conversation about how doing something with that material would help. But you didn't, it's your testimony that you would not have closed the case because there was still offending materials on the property.
Correct. And then an inspection was conducted the following week, as we do with repeat inspections, and the gate was open and they failed again. And that's
Okay.
why we're continuing to be here.
Do you have any other questions for Mr. Charlton?
Yes, sir, because he himself said, as long as that cardboard box behind there, everything else looks good. You're good to go.
Well, that's your testimony, but I want to know what
Right.
your questions are for Mr. Charlton so I can say, okay, you're done.
Did I or did I not have Miss Olson come by and she said, well, it's this and that? And I said, no, it's cleared. You could talk to the boss. And you said to me, okay, fine, I'll talk to him. And then that was the end of it. They never came back. They never told me whether it passed or failed or anything. It just seems that they're more interested in trying to get us on anything they can and everything they can than they are to doing their job. That's all, my final word, and I gotta go.
Can I say one thing?
Are y'all done with your questions for Mr. Charlton?
I'm not done at all.
You got to ask questions because I'm going to release him.
Okay. On the date that you talked to my dad on the phone, I was standing right there. You said, did you not say that what's on the back of the truck, when you found out it was a new air conditioner and the box was behind it from taking off of the air conditioner, it was in a cardboard box, the air conditioner, brand new. We just took the box off and set it behind the truck. Did you not say, pick up the box and it's clear, you said on the phone, you're good, you will not be charged anymore, but you still have to go to the hearing, is what you said?
No, I did not, because I told you I couldn't see behind the fence that day. I could not see, but that debris failed your inspection, and that I could not close the case because he was insisting on trying to get me to close the case, and I could not.
He's lying right now.
But guys, here's the thing. Honestly,
whatever.
here's the thing.
You know
Sir, stop, okay? I mean, you have the right to make your case. I'll let you make your case. But what I'm saying is, even if you were right, and frankly, I believe Mr. Charlton. I don't think there's that much of a disparity between what you're saying, okay? I think that the disagreement is whether or not he promised to close a case. Here's the thing. Because this is a repeat violation, you already have something in the past, it doesn't matter what he said, because there would be fines anyways at the time that it started.
But it wouldn't make it a repeat offense because
No, it does.
They told me from the get-go, put up that fence. and
But
that's when
on
I
day
put up
one,
that
No,
fence.
on day one, no
right.
matter what you do,
So,
it becomes a repeat.
I understand that, and I understand that. The violation, the first violation was about the cars parked on the easement.
I'm not even, that's not here. I mean, whatever that
Well,
was,
that
it's
was the
not why
start
we're
of
here.
this whole case. That was the reason why she said she looked
Guys,
in the
we're here
fence.
on a junk case. All right, so I'm looking at the photos, it's junk. It's not in an enclosed building, it's not, this is easy for me.
What makes it enclosed? Do I gotta put like netting
What,
over
what,
the top?
where's the
Yeah.
junk? That's what we want to know.
That's a good
because
question, okay? So
You could show me and I can explain.
it says completely enclosed building, all right? So like putting a tarp over it doesn't do it, even if it covers the whole fenced area. I'm looking at, for the definition here. I mean, that's, let's see. There's no definition of building in this section, but I think it's pretty common sense what that is.
No, it ain't because they can say it's one thing, I can say it's another. It's not. I need to
Well,
know
you're
what
you're
it is.
right. Well, it's certainly something that's fully enclosed, all right?
Yeah, I could close it with a tarp over
But
the
not a
top.
tarp, because that's not something that is permanent, okay? So a permanent, something that's permanent.
I don't think it has to be
It has to
permanent,
satisfy
sir.
the Florida Building Code, you know?
Does it say that in there? Or?
I don't
Well, I'm
think-
telling you, I'm giving you what I think is good enough.
I'm not trying to be rude or
Yeah,
disrespectful.
yeah.
But what you think could be, not saying you're wrong,
Right.
but it could be wrong, and then that just gives them the
I
right
know it's hard to
keep
believe.
fighting.
I have been wrong before, but I'm trying to give you some guidance on where I'm going with this. A building, I wish it was defined, right?
It could be like a carport.
Well, how about this? Let me just look up a definition. I'll tell you what I'm going to go with. This is not an advisory opinion. I'm telling you where I'm coming from. Let's just see what an acceptable definition is to get everyone on the same page. All right. The definition of structure is a building of any kind, either temporary or permanent, but I'm not.
Temporary or permanent.
but I'm not finding that. Let's see.
The definition of building I was able to find is a structure with a roof and walls, such as a house, a school, a store, or a factory. So something permanent.
We just read.
Something totally
No, that
different.
that was structure that I read, but where are you getting that definition from?
Give me 1 second to grab it.
You could read 10 different definitions.
So according to Merriam-Webster, it's a roofed and walled structure built for permanent use.
Okay, that's what I'm going to go with. That's what I'm going to find as a building. You got to get your junk in a building.
Okay.
Okay?
But where I'm having a misconception is because now they're going to charge us for all these days when.
That's correct.
But we ain't. Well, we stopped calling. We stopped doing everything because he told us that we were good to go. That we just had to show up on this date. That's why I haven't called or done anything.
But you guys,
I
I
clean
mean,
them up every time.
I've got the notice. I've got.
But the notice, sir, was only about the cars that were on the outside of the fence. It wasn't anything about inside the fence because we moved the cars that were all tagged. That's what they originally went there for, the cars parked outside the fence, which again is against the law because the law says you can have your vehicles outside on an easement.
So let's, hold on a second. So Ms. Olson, I see that on page 7 of Exhibit B, you have an affidavit that I guess was just signed Monday? Did you just sign an affidavit for this case on Monday?
Is that the posting affidavit?
Yeah, about the serving?
About the
About
what?
the service?
It was missing from the file, so I just had to re-sign it, but I did post it on the day. There's pictures to prove that.
What it says is, I have attempted to serve a notice of violation, notice of hearing via certified mail. I mean, did you serve it by certified mail?
It does get sent via certified mail,
Okay.
sir.
Well, was it sent by certified mail?
Yes.
Okay. And it also says that it was posted on the subject property, and you have a photo from July 7th
Yes.
of the photo. I think what they're saying is this notice wasn't for junk. Is that right?
That notice was for that.
What, sir? Gosh, I swear.
He's doing good. Let him do it.
Well, ma'am, I just, was that for this case or was it for another case?
No, that was for this case, the junk case, because it's a repeat.
On July 7th?
Yes.
Was there originally another case that you came out on regarding?
Yes, so the original complaint was for obstruction in right-of-way. I went out and I red tagged all the vehicles that they had on the street and on the street that runs perpendicular Kings. Due to the case being called on their property, I was able to see that there was junk and it was a repeat violation.
Y'all,
And the case was opened.
I can see on the notice, it is the notice of violation regarding junk and debris. This is what was posted on July 7th.
But that's fine. I'm not arguing that.
Well, y'all were
but
arguing.
I swear to God,
But
he
yeah,
cleared us.
we cleared all the cars and all the debris that they gave us that issue on the 8th.
Guys, here's the deal. It sounds like it's still not in compliance as we speak here today. I've now given you.
That's not true.
Okay, well, is it in compliance or not?
It was not in compliance on Monday when
On
I
Monday?
did my final inspection.
What are you requesting? What is the county requesting?
The Citrus County Code Compliance Division respectfully requests that the special master assess the following penalties and conditions in response to the ongoing code violation observed at the subject's property. A fine of $300 per day for each day that the property remained in violation, beginning from the date of the initial inspection on July 3rd, 2025, through August 19th, a total of 47 days amounting to $14,100 in accrued fines. A continued fine of $500 per day from August 20th, 2025 forward until the violation is fully abated. The imposition of administrative costs associated with the enforcement of this case. In addition, the Code Compliance Division respectfully requests the authorization for staff to enter the property to verify compliance once the violation has been corrected, that the respondent be ordered to contact the Code Compliance Division once the violation has been abated in order to schedule a reinspection and confirm that the property is in compliance.
They recommended that much money, which is double than they asked anybody.
And we don't have that kind of money.
I do. It's even on the property appraiser aerials.
This stuff has been here for years.
Yeah.
We've already been abated for years, and this stuff has been here for years with no problem. And now all of a sudden it's a big problem when we've already been cleared several times for all that stuff that's been there.
What's on this? Are y'all living on the property?
Yeah,
I mean,
we
who
live
lives?
there. It's our house. And this stuff's been cleared numerous times with no problem, and now all of a sudden we can't have stuff behind our
Why do you guys have all this stuff there?
that's what I do for a living. It's worth money. All that stuff might be junk to her, but it's not junk to me. I get paid for that stuff. I'm a recycler. So it's not really junk. It's really a valuable materials that I recycle.
But it's owned residential, right? So, I mean, that's part of the problem too. Although you're not here on that, but that's probably coming down the pike as well.
Oh, they'll be coming.
But do you get my point? How
I get
been
it.
Here for years, and they've made it clear that we're good to go for several times, not just this time.
I don't think so. In other words, I don't. I know I haven't said that. And
if you look at the records, where they charged me $3,000 something.
Yeah.
It was cleared at that point. Okay, this stuff has been here long before that point, so it makes it.
It's always been there.
So actually, I think I understand what you're saying. So hold on, let me look at this. This is the same address.
Yes,
yeah.
sir. And that's the only point I'm trying to make. That it's been cleared numerous times.
Well, the more things change, the more they stay the same. So in October 2021, John Darmiento testified that his business is scrap metal and the junk and debris is the result of his business. He stated that the amount of junk and debris changes constantly and feels that he is performing a service for the community.
I clean up all kinds of jobs that they're at.
Yep. Code Officer Matt Hampton testified that junk and debris rotates between this and other properties owned by the respondents. Special Master Christian Waugh takes a few moments to review the code section with Mr. Darmiento. So it is interesting that 4 years later we're doing the same thing.
And it's the same debris in that yard. If you look at them aerial photos and the photos, same exact debris has been there for years in a pile waiting for the price to go up. And it's been cleared numerous times. I've abated it several times, and I put a fence up that's what they told me to do. Put a fence up and it will abate this problem. And I put the fence up. Now it's because she can see through my gate.
Now I'm reviewing the 2023 case.
And I understand you work for them, but sometimes you have to put them kind of in their place so they're not hurting our community.
Well, much to the county's chagrin, I do rule against them from time to time, as you may have seen. But I have to do it based on evidence, and I'm now reading 2023 case. Ms. Harrison was here at that time.
It was cleared. Same junk in the yard. They told us just put a fence up. You'll be cleared. We put a fence up. We were cleared for 2 years now. All of a sudden, she could see through my gate. Now it's another problem.
The only reason why she was there to even see through the gate was for her.
This is in
to tag the
2023.
cars.
John Darmiento testified that every time he turns around, a code compliance officer is at one of his properties. He feels that code compliance is targeting him. He stated that code compliance is power crazed. Special Master Christian Waugh explained that the code compliance is complaint based, and if his properties were not in violation, code compliance would not be at any of his properties. He also stated that since John Darmiento is not one of the owners of the property, his appearance and testimony is considered coming from the public. That's right. There was an issue as to whether or not considered one of the owners at that time. That was a repeat violation, and on that order is $250 a day for 8 days for a total of $2,000. And I don't think you had a fence at that time. So that's when you built a fence.
And it was cleared after the fence was put up.
Well, according to this,
Because then I paid the other $3,000 or something, or $5,000 after it was cleared when I put my fence up. And they said, as long as it's back there, you have no problem. And now she's coming around checking whenever we go in and out for groceries. She's sneaking up on it.
Is there a... So I think it says here $3,028. Did you say 3,000?
$3,228.63.
Is what accrued based on the 2023 case.
Yes.
And I'm just looking.
They see I'm a good payer because they take all my money.
But
so
it couldn't be the case that the case abated with a fence, because I'm looking at an aerial of May 5th, 2024, and there's no fence. There's just junk. So the case did not abate in 2023 based on you putting up a fence.
No, I just put it up in this last case where I put.
I mean, am I mishearing? Am I mishearing what you're saying? I thought I heard you say that the 2023 case abated when you put up a fence.
The 25, the last
That
case
was
I just
finished.
had, I just was here 6 or 8 months ago
Yeah.
with you.
Yeah.
I put up the fence, that case abated then, okay? We were good for.
Was
6
that
or
on
8
this address?
Yes. Yes, sir. And we were good for a year now, it's been. At least, close to a year. We've been clear and good, and now she's.
By the way, I want to thank law enforcement for being here. I appreciate your patience. At any rate, let me, so was there a case this year on the same address?
Not on this address. I believe there was a case on one of their other properties.
Because that would have
There's
been a
several
repeat
cases.
violation.
It's right in the paperwork. There was definitely a.
Mr. Charlton, I mean, was there another case open this year on this property for junk?
They do own several different properties.
I know.
It may have been a different property. He keeps referring to the fence. I'm thinking he's maybe thinking about a storage on a vacant case that was off of Homosassa Trail, that he had to remove the items, and he asked about a fence then.
I remember, yeah.
But still, though, he removed all the items that cleared that case.
I believe that got a permit, and that's why that case
Sir,
cleared.
Yeah, I remember that. I mean, I think it wasn't this address.
It's 100% fact, black and white. I got charged $5,000, okay?
Yes.
And I came and paid it at 3625. I put up the fence and I was abated after that, and I paid the $5,000.
But
Yes,
if that's
sir.
true,
That's
then
100%
why is
true.
it that on May 5th, 2024, on the aerial, there's no fence? On the aerial photograph.
There might not have been a little piece of fence across the front, but that whole place was fenced out all the way
Yes.
around.
There was okay, I mean, I see a small,
And then they made me put up the fence all the way across from there to there, and that's when I abated. Because they said you have to put a fence all the way across. And they're actually sitting here lying on the oath saying that there's not a case. That's horrible. It's in black and white. And then I didn't put a fence up. That shows you they're absolutely lying over
guys,
and over.
the more you keep accusing them of lying,
letting you
I've
see.
heard what you said, but it's just going to inflame. It's going
Yes,
to
sir, I understand.
make
Sorry.
it sound like, what if I find against? What if I find, I mean, you've always accused them of lying. They have not been, okay?
Okay, sorry.
I just can't reconcile this. I really don't understand how you think that you could keep having junk there after all these cases. I understand what you're saying about the fence, but I've seen in the photo, I can tell that the fence did not go up at that time to abate it. You just moved, you cleaned it up. I mean, that's why the case abated.
That's
you cleaned.
absolutely wrong, sir. I'm not trying to tell you you're wrong. I put up a fence across the front of my yard, and that's when I was abated for that.
Mhm.
And that stuff has been sitting there ever since. It's not moved. There's not been cleaned up. A fence was put up, and that's what abated a violation. And that's when I paid, and I ain't had trouble in a year or so.
I mean, the one issue, the only issue, and the reason why I've been agonizing about it is I'm concerned about the manner in which the last case abated. You know, if it abated based on, you know, Mr. Darmiento, that argument just doesn't carry weight, because even if you put up a fence, if you've still got junk, it's a violation of the junk code.
I'm telling you, you can look through the documents. If you take some time, you look through the documents, you get all the paperwork together. I was abated for putting a fence across there and blocking that debris
I don't
in
think
my
so.
backyard.
I think you cleaned it. I think that if you were abated based on the fence, they abated it not because there was no junk, but because they either couldn't see it or you cleaned it up and got the fence up. I mean, that's what I think. And then
call you a liar.
and y'all, well, that's okay. You've already called me. It's okay. I've been called worse, like a lawyer. So the thing is that, again, no offense, Miss Harrison.
Well, then we'll have no choice but to put ourselves at the mercy of the court.
I mean, but these fines, I mean, I don't think that's fair as charging us that much money. And because we were cleared.
How many,
truth.
you were cleared, but how many cases is it gonna take before y'all stop putting junk somewhere?
Well, I thought we put up the fence, and that was what I'm telling you.
But it would cost less to just rent a warehouse or like, somewhere you can store this stuff. You can't keep putting it on a residential piece of
Every
property.
property we buy, they come and tell us we can't put it there. So we
But
gotta.
it ain't that. This is the problem, sir. We were abated for putting the fence up. They told us just keep everything behind the fence, and that's what we were doing. So I don't.
Here's what I'm gonna do. Is there anyone else from the public who wants to be heard? Ma'am?
I just have a question.
Well, you can come up and be heard. Put your name on the record. We'll swear you in.
Please swear to tell the truth, the whole truth, and nothing but the truth, so help you God. I do. Please state your name. Elizabeth Schmeer. Thank you.
And if you could just speak in the microphone, make sure.
Sorry.
No, that's okay.
I've watched you tell everybody, but, so I was listening and I was trying to understand. It's my understanding that code compliance is by complaint based. I don't know if I was understanding it wrong, but it sounded like they were saying the complaint is on automobiles that they got rid of. And when the code compliance officer came, so the gate opened and saw stuff behind the gate. But if that was an actual complaint that was filed by somebody, that they have junk in their backyard, then if it's only complaint based, why were they acting on it, I guess is my question.
All right, thank you.
Thank you.
I'll tell you, the reason is that code isn't required to stick its head in the sand any more than law enforcement is if they see something that is wrong. In other words, if law enforcement is called to a crime scene based on allegations of a trespass and they see someone with a bullet in the head, they don't say, nothing to see here. So there's similarly with code enforcement, if they're called out on something else and then they see other violations, is the law broken or is it not? It's complaint-based to start the investigation. In other words, you can't anonymously call and just sick someone on someone else. So that answers that. Is there anyone else from the public who wants to be heard?
Am I allowed to ask her a question?
Yeah.
So the day you came, was it about the vehicles that were in the easement? Was that the reason?
The initial complaint that I received was for obstruction of right-of-way, which is why all the vehicles down the road on Alabama and on Kings were red tagged.
Yeah, but that's against the
Hold
law.
on, I got another question. How long until they were removed? All the vehicles?
I believe I went out there.
Objection relevance. We're not here for the vehicles.
Well, I don't know. Mr. Darmiento, please speak into the microphone. And
I would like to know how long till the vehicles, because you said you were there for the vehicles, so it is relevant. How long until they were removed from the easement?
Your objection's noted. I want to hear. I don't really understand where it's going either. But
So our red tags that we place on the vehicles give 3 days. So without my paperwork in front of me, because that case is not being presented, it was probably 3 or 4 days.
Well, now they don't want to present that case, but another question. So they were moved, and within 24 hours, less, but I'm just saying 24 hours, they were moved right down the road to a man's property. Within 24 hours, because she called back and said that they were on another property, right?
Mm-hmm.
You knew they were on the other property down the road within 24 hours. There's no way that someone else could have complained in less than 12 hours that I had all the vehicles moved and down the road. There's no way someone could have complained and said they're on another property. So she hunted my vehicles down at that property, called this homeowner, another homeowner that had vehicles at his property, begging him more than 5 times to take me to jail and press charges on me.
you're saying what you're testifying to is that Ms. Olson called a homeowner begging to get you in jail?
More than 5 times, begging him to press charges on me.
For what?
For putting junk on his property. Is that the truth or not?
That is not the truth.
How would law enforcement be able to do that?
So I received complaints for this property off of Kings Avenue, which has abated, so it's not being heard today. She called in because she said that people were dumping stuff on this property. And then she also said that she was tired of the obstruction of right-of-way stemming from their property on Alabama. So I had cases on this property on King Street. So when they removed the vehicles out of the right-of-way and I went to inspect my property that I already had a case for on King Street, I could see that the vehicles that I red tagged, I could see my red tags on the windows of the vehicles. As far as the allegation that I pushed them to press charges, that's not true either. The property owner called me and said that they had dumped stuff on his property without his knowledge, as he lives out of state. And he didn't want to trespass them, because then all the stuff would still remain on his property and he would be at fault.
Okay, I understand. Then you know, the interesting thing about your questions is they're not 100, like, there's actually more overlap than would meet the eye, but it doesn't sound like sounds like there may have been a criminal case.
Well, no, I got text message from the homeowner, and if there was a way I could show you or show the court that she literally asked the homeowner more than 5 times. He's actually appalled by how many times she has begged him to press charges, because then after he would press charges, there was a county easement on that property too, which then she would be able to get
Guys,
charges
this is
pressed.
a junk case, and there's junk all over the yard. All right, so what I'm going to do is I am going to find there's a violation. I'm going to find that it's a repeat violation based on the past stuff. I can't stick my head in the sand.
Well, you see the fence in the picture, right?
Which isn't good enough. It doesn't give you a license to fill your property with junk.
But if you go back to the last violation where there was no fence, then I put up the fence, which was still the same junk in the pictures.
I don't agree. I don't agree.
But, Your Honor, the only reason why she was even there was about the car.
Which, again, is irrelevant to whether or not the violation exists. You don't get a free pass because they're there for another reason any more than you would any other violation.
Right,
so here's the issue. The goal of the code compliance is compliance. And the reason why code has requested that it be $300 a day is because the last one, I think, was $250 a day, and the one before that was $150 a day. And there's very, very few tools that I have to actually enforce the code. This is it. So really what they've requested is restrained, I think, because they're not going up that much. They're going up, they could go up to $1,000 a day. They're requesting $300 for the prior violations, which, by the way, at any time, this could have been abated. From the time of notice, July 3rd, y'all could have gotten all this stuff on the property.
But, Your Honor.
And I have photos, but wait, I've got photos as of the 18th that show it, and I don't understand.
There's a big gap in there where he told us that we were clear, and now all of a sudden they must have seen something else in the yard on the 18th. And
There's no way Mr. Charlton would have said that, because it's a repeat case. So it doesn't make any sense. That proceeds.
You wouldn't be fined. You still have to show up to court, but the fines.
That's not
at
the
this
way a
date.
repeat case works. That's why I know Mr. Charlton wouldn't have said that, because that's not how it works. Like I think, and you guys actually agree on some of the stuff that he said, which does make sense. But a repeat violation doesn't go away that way. So I think what I have to do is find that I'm going to assess a fine from July 3rd until yesterday in the amount of $300 a day. And from today's date forward, it's going to be $500 a day. You've got to fix it.
You can't give us a break on the 500 till we can get a few days to clean it up.
Yeah, what exactly do they want us to clean up and
You do have remedies. One is, of course, you can appeal my order, which you've indicated you would do in the past, and I encourage you to do so if you think I'm wrong. But second of all, you can always request some kind of fine forgiveness later on. Now, with a group of people who you've accused of lying a great deal, I don't know that that's likely to be granted. But there are remedies. It's happened before. You know, sometimes you go to sell a property and they might work with you on it.
Well, they told me that after you've been fined, I don't know how true it is that you can't get the where they cut the fine down.
I've seen it. I don't know what. That's not necessarily that they're willing to do it.
If repeats can't be forgiven
Oh,
for a
repeats.
repeat
Is that in the code?
violation, it's AR.
It's in the code that it can't be reduced? I take it back, so you
But
can't.
the thing is this, sir, they already had, and when you came to the house, when he came to the house, it was done. It was done, okay. It was cleaned, it was done, he said
I think y'all made progress on something, and he told you that if you fixed it, that specific thing, but I know that's not how a repeat case works. I understand what he did and did not say. I think you might have misconstrued it, but it doesn't even change the fact there's just junk all over. So
all I'm asking is if we could keep it at the 300 to give me 10 days or so to get, because there's a lot of stuff there that I just have the
okay,
thought
so
of
Mr.
the
Darmiento,
fence.
it's $300 a day going up to yesterday, right? Okay, that's done.
Why is
Based
that?
on your request, I'll give you $300 for the next 10 days and $500 a day after that. Okay? All right.
Next case on the day's agenda. Megan B. Hamilton, case number 2024-1664. Code Officer Cody McGuire, page 20 of your agenda. Expert on the case, Land Development Director Joanna Katoot.
Your Honor, on the last case, we requested access to the back.
I'm putting that in as part of the order.
Thank you.
Thank you.
Okay. How long did that take?
Probably an hour.
Yes. Megan Hamilton.
Good morning.
Good morning.
Are you, dare I ask this, are you contesting whether or not there's a violation on the property? You can, I'm just curious.
It's a unique situation. Well, it turned into a unique situation.
Okay, well, then let's go through it then. Good morning.
Good morning. Ready?
Yeah.
All right, Cody McGuire, Citrus County Code Compliance Officer, case number 2024-01664, a violation of the Citrus County Land Development Code Section 4002, site development order or permit. Address is 10221 West Spring Tree Lane, 0.96 acres, and is zoned LDR. The property owner is Megan B. Hamilton. Good service via posting the notice of hearing on the property and posting at the Kendall Government Building. I'd like to authenticate the following documents and request they be admitted in evidence. Exhibit A, photos taken during an initial inspection on September 19th, 2024. Corrective action inspection on April 17th, 2024. And photos of my pre-hearing inspection conducted on August 18th of 2025. There's also a subsequent inspection photo in there dated December 27th of 2024.
What's the narrative on this, Mr. McGuire? Like, what's going on?
So what happened is she removed a couple trees and had loads and loads of fill brought in and spread. And then it transpired into a shed being put into the back corner of the property and a unity of title.
You said unity of title?
Mm-hmm.
I mean, is that related to this in any way?
Yeah, I'm gonna have to refer to Joanna Katu.
So they have a lot, adjacent lot with a house. They've added a shed onto this lot, and they did a unity of title, which will allow the shed to be placed there. It says they're tying together as one development permit forever. She did not get a permit for the fill and the grading. Still needs to have that. That could have been part of the shed permit, but the shed permit is closed, I think. So they have to open it up to do the grading and the fill. That's all that's left. They're almost to the finish line.
Okay, so this is just at this point, the only issue is the unpermitted fill and
grading,
and
right?
Grading.
Right. The
Okay.
tree removal could be allowed as part of the shed.
Okay.
Yeah.
Okay. Are we all on the same page about what's going on? Does that make sense to you?
Yes, just a little bit more information that I've just now found out.
Okay. Well, I mean, what they're saying is the only issue right now is there's an unpermitted grading fill that was done as part of the project, and it sounds like no one's begrudging you for doing the unity of title and getting everything sorted out. But how much time do you need to get a permit?
Can I state my side
Yeah,
of
of course.
the
Go ahead.
situation?
Yeah.
So the house was in probate. My grandparents passed last year, and I had the trees removed because it was right before that hurricane. And the center one was actually leaning towards the power lines. And I didn't know that that was a violation.
You're not here on the trees, I don't think.
That's
It's more along, it was just a couple trees, nothing really worth writing home about. It was more along the loads of dirt that were brought in and spread.
that was the initial violation that
Okay,
you guys
that's,
issued.
I understand, but we're really here on what you need. It's just, that's why I was telling you, it's really just the grading and the fill at this point.
The dirt was brought in December to help even out after the trees were
Which is
removed.
illegal without getting the permit. So that's why I'm asking, how much time do you need to get the permit?
Well, that's just it. I have the permit on the after the fact shed that they had me get, and I was told that that would wipe out my violations, and that's what I did. So
Oh, you're asking for a one-time fine
One-time fine,
based on
yes.
putting it in without a permit. I'm
Correct.
sorry, okay.
And the dirt
Why
company-
would you, I mean, I guess what I'm trying to figure out is, so you've got the house on one parcel, you've got the shed on the other parcel.
Right.
You're unifying them,
So I can utilize the property as
of
a whole.
course, and you put fill in.
Yes, so that I can maintain that property. It's on Lime Rock, so it's really hilly. So when I had the trees removed, it made it worse. And
Well, right.
yeah, so the dirt got brought in so that we could do the grass and actually mow it, and it would unify and look nice with the rest of the property, because it's a beautiful property.
Well, are you contesting whether or not you needed a permit for the fill? I mean, I understand you had a
The
good reason.
company said I didn't, so yes, I'm contesting that because I didn't know, or I would have had a permit. I mean, I jumped through hoops getting the after the
All
fact
right,
permit on the
let's
shed.
look at the photos and everything. I would just go through the exhibits and let's see.
Yes. I'm not
real quick.
contesting the photos.
Okay. Yeah, it'll help me understand. So let me ask you this, Mr. McGuire. So did they go and get the permit for the shed?
Yes, sir.
There's no argument about that.
None.
And there's no basis to believe that at that time, they would have been able to do grading or fill?
Well, the grading and the fill was at the front of the property, nowhere near where the shed was placed.
Okay, I do see that. What are these signs?
Neighbor love.
I have a neighbor that's in everybody's business, and that's why I'm here
And
today.
probably made the complaint. Well,
Yes,
Hey,
so-
that's the law. What's the county requesting?
A one-time fine of $1,500.
Are there members of the public who want to be heard on this case? Sir?
No, I didn't say that.
You did, twice. All right, so let's see. I just want to make sure I understand. So this is, why did you put the fill in? Just because of the tree removal and to make it?
Yeah, so I can
You
get the
can't do it without a
property
permit.
I wish they would have told me that before I ordered it, though.
Yeah.
Nothing to code, that wasn't
Yeah.
anything on them, that was just me trying to level
Um,
out the holes.
I've never given less than 2,500, so I thought that's interesting that the county's only requesting 1,500 for doing it without the permit. The reason being that if you let people do things without permits, everyone comes in here and says they didn't know, so it has to be some kind of deterrent value, but I will find that the property's in violation and do a fine of $1,000. Okay?
Thank you.
Good luck.
Next case is Andrew Joseph Quintero, case number 2025-922, Code Officer Julie Wilkinson, page 28 of your agenda. Expert on the case, Joanna Coutu.
Good morning.
Morning.
Julie, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Yes. Please state your name, sir.
Andrew Quintero.
Thank you.
Okay. I just asked in the off chance, but are you contesting whether there's a violation on the property?
No.
No. Okay. And what is the issue here, Ms. Wilkinson?
The issue is site modification.
What was the modification?
He took down some trees and brought in 400 cubic yards of fill.
So similar, just on a bigger scale to the last case?
Yes.
Okay. Sir, why'd you bring in the fill?
To bring it up to the road.
Okay. It's a low, kind
It's
of a low.
low. Since I got the first notice, I have applied for a permit. I'm waiting on a survey, and I have the permit number here.
I suspect they're going to request a one-time fine, but I don't know. What are you requesting?
Yes, it's going to be a one-time fine, but for $5,000.
How big is the property?
0.11 acres.
0.11?
Yes.
I mean, so this, do y'all have photos?
Yes.
Could you show them to Mr. Quintero? And I just want to see. Let me know if you have any objection to me looking at them or them being evidence. Okay, thanks. Your intention is to build on the property like a home or something?
Yes.
Okay. Is there anyone from the public who wants to be heard on this case? All right. I mean, again, normally what happens is the county has to hold the line. They could go up to $10,000 on a fine like this. They've requested $5,000. Normally, I do $2,500. It is a little bit. You said 400 cubic yards? How do you know?
Yes.
How do you know it's that much?
Oh, in the permit that he applied
Oh,
for, he stated that he brought in. Yeah.
He told the truth. All right. I'm going to do a $1,500 fine and call it a day. All right. Thank you. Good luck.
Thank you.
Next case on today's agenda, Elizabeth Schmeiter. Hope I'm pronouncing that right, sorry. Case number 2025-1028, Code Officer Julie Wilkinson, page 29 of your agenda.
Page 29? Okay.
Expert
morning
on the
again.
case,
Good
Joanna
morning.
Coutu.
I'm ready.
Yeah, this case number 01028, violation of Citrus County Land Development Code, section 4002, site development without a development order or permit. The address is 4215 West Vizcaya Lane in Citrus Springs. The property owner is Elizabeth Schmeer. I have good service via signed certified mail return receipt. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos I took during my initial inspection on June 26, 2025, photos from a corrective action inspection on July 16, 2025, and photos from my final inspection on July 19, 2025.
You mean August 19th and August 16th?
Yes, I
Okay.
apologize.
Okay.
Thank you. I also have aerials from the Citrus County Property Appraiser website dated January 16, 2017, January 18, 2019, December 15, 2021, September 7th, 2022, May 31st, 2023, May 5th, 2024, and June 20th, 2025. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, and a copy of the signed certified mail return receipt.
What is the narrative on what's happening on the property?
The narrative is she had removed some trees and has slowly been removing trees since she bought the property, and it's a vacant lot.
Okay. Ma'am, are you contesting whether or not there's a violation?
I'm not actually contesting it, but because I was told if I contested it, the fine goes up.
Well, that's not true. I
Well,
mean, it's a possibility, and I think I brought it up at the beginning of the hearing that sometimes y'all can come to a resolution, and it may be that it's a fine that's less than what I would do. It just depends on where I come. I don't care at all whether you contest it or not. You know, if you feel that you have a good faith basis to do so, you have that right. And I'm not, as you heard in the Darmiento case, I'm going to let you say what you want to say to lay the record. Because the worst thing that I can do is not give you a chance to defend yourself in a hearing like this. So either you're contesting the violation or not. It sounds like they have considerable evidence that over time, trees have been removed from the property without a permit. But do you feel that's not the case?
I don't feel that's not the case, but that is what Miss Wilkinson told me on the phone after she went and spoke with her boss, she told me that the fine, this exact word, the fine will be $2,500 if you don't contest it, or $5,000 if you do. And it left me speechless for enough time that she said, you don't have to give me the answer right now.
Well, regardless of what was said, I can tell you that it's not the case, right? So, I mean, either you're here, right?
I am here.
So
I'm here to state my case.
Then state your case. I mean, what's the basis? Actually, let's get these exhibits then. How about this,
Yes.
Ms. Wilkinson? Can you show these documents to her? And
Thank you.
ma'am, let me know. And how do I pronounce your last name?
Schmeer.
Schmeer, okay. Then, Ms. Schmeer, look through them. Let me know if you have any legal objection to them. Okay?
Mhm. Can I just ask where the dates are on?
So, I mean, they're there. I don't,
Well, the pictures demonstrating taking down trees over a period of time, that's why I'm asking for the dates on those, the aerial photos. I mean, the date is, okay, I see one.
and she's already put the dates on the record as well, so
I understand.
yeah.
Sorry, one of the paper clips came out. I didn't realize there was two.
That's okay. They don't have to be perfect. All right. So I haven't heard any, bona fide legal objections. I've got some concerns, and we can talk about them. Without objection, what's been proposed as Exhibits A and B are evidence, and I'm just going to take a look so that I'm on the same page.
Mhm.
All right. Please proceed.
This property is listed on the property appraiser's website as a vacant lot, 1.15 acres, and is zoned rural residential. I conducted an initial inspection on June 26, 2025, and observed that trees had been cut down on the property. While researching the property, I observed that there were no permits issued or applied for. I conducted a corrective action inspection on July 16th and found that no permits had been issued still for that property. As of my final inspection on August 19, 2025, no permits were issued or applied for. On June 3rd, 2025, I had contact with the property owner, Ms. Schmeer. She purchased the property in February of 2021, which coincides with noticeable gaps in the tree canopy beginning to occur when looking at the aerials from the PA.
What evidence does the county have that the trees that came down weren't dead.
I don't have any evidence for that.
Okay.
Your Honor, so I have been a resident of Citrus County for 31 years and a property owner for, well, since I think 1999 was the first property I bought. And in doing different things to the properties, I've always called the building department to find out, do I need a permit for this or do I need a permit for that? Over time, I've replaced windows in one house I owned. At that time, you did not need a permit if you did size for size. And
What,
there
what
were-
do you mean? Oh, like if you took down and then put
if
something?
you put a new window in that was the identical size, you did, and that was a long time ago.
I was going to say, the code has changed.
Yes,
since- yeah.
yes, it has changed. But at that time, it was a long time ago. I think it was in the early 2000s.
Okay.
And I've also called for, in different times, did you need a permit for a fence or did you need a permit for a tree? Okay. So coming to current day, property next to my home became available and I eagerly purchased it. I was unaware that you can purchase property and pay taxes on it year over year, and yet you can't even park a vehicle on it. So, and this is what I was actually told. I had a conversation, a pretty lengthy conversation with Miss Wilkinson about that, and she said, no, you can't have anything on it. I said, so you can't even put a swing set on it? She said, no. You
The
can't.
vacant land.
Yes.
Yeah.
She said, no, you can't. She said, there's got to be a building on it. You either have to do a unity of title between the properties or,
Because you can't have any of those accessory or, secondary uses until you have the principal use established on the property. And that's why you'd have to do the unity of title.
well, and I understand that
Yeah, yeah,
now.
yeah,
In fact, I really wasn't clear on it, and I made an appointment with Commissioner Bays. And I had a meeting, and Mr. Charlton came in, as well as this gentleman who I still can't remember his name. I did ask him at one point, but I still don't have it down. And I'm not looking to make enemies with anybody in the
Right.
county. I mean, I live here.
Right.
But, so when I bought the property and I really wanted to be able to sell the house I was in eventually, I asked my significant other to just park the truck and trailer over on the other property. There was, when I purchased it, and you can see from the aerial views even from years ago, there was a significant clearance in the middle of it. And I told him, do not cut down any trees on the outside periphery because I wanted it to remain as secluded as possible. Now, even when I cleared the property on the house I bought in 2009 through Clark Construction, I told him that I would be willing to hire him, but only if the pine trees that he took down they were repurposed through another company that did whatever they do with pine trees, whether it's cutting into lumber or whatever. So my point is, I know that he took down some trees, and I went to Ms. Bays about it because I couldn't understand how can you own property and not be able to do anything. And after I explained to her everything that I did, she said, well, the ordinance was not really put in for this kind of a situation. It was put in because we have people putting sheds on vacant land and living in them or whatever it may be. She said, it looks like you were just kind of caught in an unfortunate circumstance because I wasn't trying to do anything illegal. I wouldn't even let him take down a tree if I knew that it was going to become an issue. But apparently it is an issue. So then I asked, because Ms. Bays brought in Mr. Charlton and the other gentleman, I asked him, where are the guidelines? You know, when you get pulled over for a traffic ticket, right? There are guidelines. If you speed 0 to 10 miles an hour, it's this amount of money. If you do 11 to 25, it's this amount, whatever it may be. So
Sometimes they have tickets for careless driving. What
I-
qualifies as that? Reckless driving. Well, what's that? But I get your point.
I was asking him, is there some kind of a list? Like, how do you determine how much money you want to fine somebody for really an honest mistake? Anyway, when I found out that I had to do the unity of title or the other, I went down to the building department. And I spoke to the gentleman, young gentleman that was in the window for permitting. And then I also spoke to a Taylor Schwing, who is a development review permit specialist. And I talked to her for a little while because, you know, I thought, well, the unity of title would have solved the majority of it pretty quickly. The only thing that wouldn't be resolved is when you do a unity of title, apparently it's irrevocable. And my the whole reason for me purchasing the property was to be able to build a home on the property and sell the property I'm living in. So when
Well,
she said,
why did you take the trees down that you did take down?
well, some of this stuff, and I explained this to her on the phone, that I asked him why he had removed a tree, and he said that there were, the trees that he took out, he said were either dead or posing a risk of falling. I don't understand the difference between pine trees, that some are pine trees and others are sand pine. I don't understand the difference. I don't do that for a living. So that was his reason essentially for doing it, for taking the trees down. So when in the discussion with Mr. Charlton, he said that I asked him what it is that he references to come about determining these fines, because when he was...
Well, I'm the one who determines the fine amount. The question that's before us is whether or not this is development without a permit. So that's really the question, you know, and I think that normally, I mean, you are allowed to take down some trees based on certain things.
So what he explained to me is that he said that it's irreparable harm to the property if you cut down a tree. It can't be fixed. And that size piece of property, when I do pull a building permit for the new house and garage, that size piece of property, I'm required to keep a minimum of 10 trees. 8 for the first acre and then 3 for each 3,000 square foot above that. There's many more trees there than 10. There was no intent to degrade or harm the property. I want to build on it, I want to live there. So, you know, I didn't think that was, I didn't know you needed special permission to take a tree down, or a few trees down from your own property. I honestly didn't know. Anyway, so Mr. Charlton had told me about the 4002, and so I looked it up, and it says about, I mean, I don't have a legal background at all. My background is in the medical field, so it's harder for me to understand all this, but he told me that it's Chapter 4002, and that it says no development allowed on this code should be established, changed, whatever, or altered after the effective date of this code, which on what I see is March 11th of this year. He did tell me that they used to impose a fine, a per day fine, I think of $100 a day until something was rectified on the property. But then when it was rectified, it was abated. The fine went up getting abated. So they decided to change it to a flat fee so that I guess more revenue could be produced for the benefit of the county. I told him I thought that it was excessive, $2,500 for removing a few trees, when I didn't know. My only experience with that was when the phone call that I made several years ago about removing trees, and they said you don't need a permit for it.
There's some, if you look at the photos, I really don't think you do need a permit for it. There's one that's like really, really thin that I don't know that you would have needed a permit for. The issue here is the number, and
the number was very few because there was a very big, see, I took pictures from inside the property.
Oh, I was still talking, sorry.
Oh.
So the issue here is the number and the size. So for example, like on page 3 of Exhibit A, I can show you one that's obviously very small, right? To me, that's, I wouldn't find that there was a violation based on taking that one down. But then on page 4, there are, it looks like, well, there's 1, 2, 3, 4 stumps that look pretty new, and then there's some of the trees are actually right next to the stumps. So it's certainly more than 3. I mean, what number do you think of trees were taken down over the past 4 years?
I really don't know because I wasn't there.
Well, then how can you say it's so few?
Because there was a big opening in the property, and that's where he was parking.
I see that, and then, so that's another thing. If we look at the property aerials, 2021, no problem. 2022, no issue. 2023, no issue. Between 2023 and 2025, it appears that opening gets a little larger. And not a lot larger, but a little larger, and mostly on the, I don't know the direction, but I'd say the southwest side opens up a bit. And frankly, one of those trees looks dead. I mean, I don't really think that that's an issue for me to take something like that down. The issue is the amount, and I've had cases where it's 1 or 2 trees that can't be a violation under, I think, a material action or development. But the issue here is the number. And no, as you state, you are not the greatest offender of this section. On the scale of 1 to 10 of issues under this code section, this is a 2. You know, this is not a 10, this is not a 9, this is not an 8. So there's no issue about a $10,000 fine or something like that, or even a $5,000 fine. Unfortunately, the evidence does show that, I mean, I count at least.
I have photos that I have taken also that I would like to submit.
Yeah, absolutely.
And I took these photos from the clearing inside the property.
Okay.
Now.
And when were they, do they have dates on them, or?
I just took them yesterday.
That's
I had
fine.
a terrible time trying to print them because I'm technologically stupid.
Then show them to the county, and then the county can let me know if they have any objections to them being evidence.
Sure. That's one of them. That's another. So this is from inside that opening, just taking around the trees around the periphery. Now, Mr. Charlton had said that, and I had discussed with
Ms. Wilkinson.
Yeah, sorry, I'm really bad on
okay.
names. I had discussed with Ms. Wilkinson that there would be coming a time on the property that I live in that I would like to be able to take some dirt from the backyard, take some dirt from the backyard out, because it's very hilly. It comes down like this to the house, just to clean it up. And I asked her, am I allowed to take the dirt that I take out of my yard that I'm living on, and then put it over there, being that I will need quite a bit.
I understand what you're saying.
And she said, no, you can't do that because that's grading the property, changing it forever. So the last 2 photos that I have.
That's an accurate statement of Citrus County law.
Okay. Well, and I didn't. We weren't really trying to modify the site. We took down a few trees.
Yeah.
I didn't bring in any dirt. So these last 2 photos show from the property next to my house, and you'll see all along the property line, the grading of the property is the same on both sides. It has not been altered or changed. You already submitted those. I don't need that to submit that.
All right, so we'll have these all a part of, I guess we'll call it Exhibit C.
Your Honor, she has exhibits marked Exhibit 2 through 8. Do we have Exhibit 1?
Yes, but it's not.
It's not being introduced.
It's not being introduced.
You've got what she's seeking to introduce, and if it's admitted, it'll be Exhibit C. Okay, it's Exhibit C, and let me take a moment to look, and all these photos were taken yesterday.
Yes.
Correct? Okay. So, what do you want me to look at here?
Well, I want you to see that the natural barren land inside of the property. He did take down a few trees, certainly less than 10 max. There was just, like I said, a big open vacant area. And the last couple of photos show that the grade of the property hasn't changed at all. I haven't done irreparable harm to the property. I really didn't want to do harm to the property. I didn't buy it to damage it.
And they'd come down anyways when you end up developing the property, if you develop the property.
Well, no, I definitely am going to
yeah.
develop the property, but not all of the trees will come down.
What's the county recommending?
I understand it's a level 2 on your scale, but I'm still recommending $5,000.
Okay. Is there anyone for the public who wants to be heard on this? I didn't. I'm not sure exactly what was represented to you, but it is the case that normally I assess a fine of $2,500 in a case like this, upon their recommendation of $5,000. I think here it's, you didn't clear the site, you know, you didn't, in other words, what I commonly get are cases where someone has cleared the entire quarter acre or 0.15 acres, something like that, to get it ready. And maybe they knew or didn't know. But
I would never have cleared the whole acre.
Right. Well, you didn't. So no one's arguing that. But I do think it is a violation. I have to stay consistent with that. And I am going to assess a $1,000 fine.
Thank you.
Good luck.
Okay, thank you.
I know we haven't made it through that many cases, but it's my intention to keep driving through.
Good.
Yeah.
Excuse me. I know you assessed a fine, but I haven't been through this process.
I'll issue a written order, and you'll just have to get in touch with the county.
Do I get something in the mail?
Yeah,
Yes.
I'll issue
Okay,
I'll
that's
issue
all
a
I
written
wanna
order.
know.
Yeah.
Thank you. Have
Thanks.
a good day.
Sure.
Next case on the agenda, James Stephen Smith, case number 2024-2125, Code Officer J.C. Charlton. Page 34 of your agenda, expert Joanna Katu. I already swore. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name.
James Stephen Smith.
Thank you.
Okay, welcome, Mr. Smith.
How are you?
Good. How are you?
Getting education.
I imagine it is if you've never been to one of these things.
Court
for,
TV.
For better or for worse. So it's not quite Judge Judy. Go ahead.
This is a site modification, Code Compliance Division Director J.C. Charlton, case number CE 2024-2025, violation of Land Development Code 4002, site modification without a development order. The address is 1312 South Estuary Drive, Crystal River, Florida. Property owner James Stephen Smith. I have good service via signed certified mail. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos I took during initial inspection on December 12th, 2024, and a final inspection on August 19th of 2025. I have a copy also, part of Exhibit A, of the aerial depicting the properties before the change and after the change. Exhibit B, a copy of the notice of violation, notice of hearing, and the signed certified mail return receipt and the pre-hearing order.
Can you give me the narrative of what the county thinks is happening?
Yes, sir. I received the complaint. I went out to the property on Estuary and seeing that there were site modifications while at the property. I actually observed the dump truck dumping.
You went personally?
Yes, sir.
Okay.
Yes, sir. I observed a dump truck dumping a load of rock or fill on the property. Further research, looking into the property from the aerial photo, it depicted that there was a small opening because at the property I couldn't tell if there were trees removed at the time, but looking at their aerial photos, it depicts that there may have been some trees removed also.
may have been or were?
Were.
Okay.
Were, I'm sorry.
I mean, it's important to be clear about what the county is
Yes, sir.
alleging. So this is another development without a permit case, and it's the county's case that trees were removed among other things like a path or gravel or fill or what?
The gravel was all the way out to the county roadway as well, and there's a path going through to the property that the photos that I took during my
How
initial.
big is the property?
That is a good question. I do not know that off the top of my head.
It's .3. There's two parcels of land together that both make up .74.
Gotcha.
So
All right.
they're like half of that.
Well, let me turn to you before we get into the exhibits, Mr. Smith. I mean, are you contesting whether there's a violation on the property?
No, I wasn't quite aware because I had bought it in like early November.
2024?
Right, and we had just gone through the two hurricanes, and out there in Ozell, there was also, after I bought it, there was also some kind of a high tide flood that I went out there. So I had brought some dirt out there for the access from the road to get back into where, it was. And then I had gone into the window of information or the residential permit office and asked about tree removal, because at the time it was just loaded with just nothing but pepper trees. And I looked up on your information that pepper trees and Australian pines are nuisance trees. You know what I mean? Because they told me anything over 4 inches or whatever. But I asked, what about pepper trees? And they're considered a nuisance trees because they're, not a native of Florida. But I, plead ignorance that he was kind enough to tell me and was working with me to make it go until this later date, because I've been trying to get permitting, and unfortunately I went with the wrong engineer, and they've been stringing me along. So the first engineer made plans that were too low, and they weren't accepted. And I just got a local guy, the CAD Tech, over there on Old Oakhurst, or Homosassa Trail.
Okay.
And they're, they just take a deposit. So I'm trying to get this finalized.
Yep.
Because I've already got quite a little bit of money invested in just the preparation. You don't realize how much hidden money's involved with just getting ready.
I do, unfortunately. What's the county wanting to do here?
Recommendation of one-time fine of $5,000.
Is there anyone from the public who wants to be heard on this case? Golly, can I see the photos?
Yes, sir. Do you want to take a look at it?
Sure.
Yeah. Let me know if you have any objection.
If I could, this is in our coastal A zone, so it's the most significant flood zone. So anything fill and gravel, that's a concern. Has to be on pilings, it has to address wave wash. There's a lot of things that weren't addressed in the permit. That was denied back on June 18th, so.
It was denied when?
June 18th.
Which is why I think he's saying.
Right, he submitted on June 10th, it was denied on June 18th, nothing since then. But it is in that coastal A zone where it's gonna have to be up in the air on pilings, and none of that was addressed yet.
Thank you. Mr. Tron? All right. Thank you.
So basically, I hope to have a permit issued by here. I think the initial permit status is until the November before, they give you so many times to get the permit through before you have to go for another permit application. So I think it's gonna hopefully get through as soon as I get the new drawing.
Well, I don't think there's any doubt about the trees on this one. Looking at the aerials. Okay.
Yeah, if you look at it, they were all just Florida pepper or Brazilian pepper.
Yeah, I mean, I see the list of invasive trees in the code, but I don't, they still have the tree removal issue there. In any event, gosh. And I see that the first photos in this case are from December of 2024. Were y'all just trying to let him work through the permit process? Bless you.
I was trying to let him work through, and then I definitely don't get out that way all the time, and I dropped the ball on that.
No, I'm just curious. I mean, would you still have brought it had he gotten the permit?
If he'd have got the permit, no, sir.
Okay. All right, then I'm going to assess a $1,500 fine, and we'll call it a day.
Okay.
Good luck.
Thank you.
Yeah.
And I'm sorry, is there anyone from the public who wanted to be heard on that? Okay, sorry, thanks.
Next case on the day's agenda, Michael Spangler, case number 2025-879, Code Officer Erica Olson, page 35 of your agenda. Expert on the case, Land Development Director Joanna Coutu.
Yes, ma'am.
Please state your name.
Michael Spangler.
Thank you.
Good afternoon, sir.
Yes, sir.
Sorry, I got a little ways.
No problem. We're getting hungry, though.
Me too.
Me too. This is case number CE 2025000879, special requirements for all accessory structures, a violation of the Citrus County Land Development Code 3102 Alpha. The address is 960 South Crystal Grove Point, Homosassa, Florida. This property is vacant, 0.51 acres, and is zoned LDR MH. Property owner is Michael Spangler. I have good service via signed certified mail return receipt and posting at the Lecanto Government Building. I would like to take this time to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on the 5th of June, photos taken during my compliance inspection on the 19th of June, and photos of my final inspection on the 18th of August. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, and a copy of the certified mail return receipt.
Can you give me a narrative?
It's a vacant property, and there's an RV that had like a porch, and he had like a whole, not him, but he had a whole setup on this vacant property, so it's storage on a vacant.
Well, now you say not him. I mean, who did?
It was a gentleman named Robert. I spoke to that gentleman the first or second time I was out at the property. He said that the property owner had let him live out there while he cleaned up the property, because I believe there was a mobile home on the property that was burned down,
Okay.
and he was cleaning up the remnants
How
of
big's
it.
the property?
It's about a half acre, 0.51.
All right. Mr. Spangler, does that sound accurate to you, or?
Yes, sir. I don't want to go into the previous, but the trailer burnt down, and I did get a permit to remove the debris, and there was just a little bit there, but I had asked him to leave, and he was going to leave. But since then, he's disappeared, and I've called the tow companies. They don't want to mess with it. I called the sheriff's department. They didn't want to touch it. And I'm afraid if I move it, I'm going to be arrested for thievery. But, you know, he's abandoned the property. I mean, if it's there for 30 days, can it be mine? I mean, I know that's,
That's a good question. So, of course, what I have to tell you is a lawyerly answer, which is go talk to your own lawyer. Pal, you're not going to get any help from me. But I'm joking. But, you know, you do need to consult your own attorney about what your remedies are in this situation. What I will say is I do think you have rights regarding this property as the owner.
Yes, sir.
Okay. And let's say for a moment that I find that there's a violation. How much time do you think you would need to go get rid of this stuff?
Honestly, I'm going to work tirelessly to find somebody that will move it. JC recommended the Smitty has the auto record, crashed cars. If he'll come out and get it, I'm willing to pay to
I bet for a good price the Darmientos will come out, and they might even be able to use.
Who
you
are
never
those?
know.
It's the case I
That said,
had.
please consult your own attorney.
Oh.
Do not listen. I'm not giving you legal advice. And don't listen to my recommendations about that. But at any rate, I do think you have the ability to fix it. So I guess what I'm wondering is how much time do you think you need?
Whatever you think is fair.
Okay. Can I see the photos? I mean, yeah, show them to Mr. Spangler first.
Yeah, a lot of this he's removed.
Okay.
You can see the time and date stamp, so.
The reason why I want to know is I want to see for myself how much time you would need if I'll know by looking at the photos.
So you're just concerned about the, because there is some little odds and ends that are laying there, but we can pick them up.
I'm not concerned about those.
Okay. If I can get a tow truck guy to take care of it, you're gonna make me read.
Well, they're the documents that were sent.
Well, by the way, I'm not saying that you can have junk on the property. What I mean is I am confident that can be cleaned quickly.
Yes, sir. Could I get a month or 2 weeks?
Well, let's look. I just want to see the photos so that I can figure that out. All right, we'll admit these as evidence just so I can look at them.
I don't even know if the guy's in jail. I don't even know his name, other than Bobby.
Well, that should be a problem for you, right?
Yes, sir.
Yeah.
And I couldn't even get, there's no tag, and law enforcement wouldn't even check to see if the thing is stolen.
Yeah, I would give 30 days.
Thank you, sir.
Yep. What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests a special master assessed a fine of $50 per day along with admin costs.
No, this one's going to be 800. Listen, this is, I'm joking. So I'll give you 30 days.
See if I was going to spaz out.
I'll give you 30 days to bring it in compliance. It'll be $50 a day if it's not brought into compliance in 30 days.
Thank
Okay,
you.
thanks.
Thank you.
Next case, Edward A. and Erica Furlong, case number 2025-980. Code Officer Julie Wilkinson, page 18 of your agenda. Expert on the case, Land Development Director Joanna Coutu.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
And your name, please?
Edward Furlong.
Thank you.
Good afternoon.
Good afternoon.
This is a repeat violation initially observed on June 25th, 2025. The address of the violation is 4336 East McCartney Loop in Inverness, Florida, 34452. This case number is 00980, special requirements for all accessory uses, a violation of Citrus County Land Development Code 3102A. The property owner is Edward A. and Erica Jules Furlong. They have previously been found guilty of the same violation at the same location on April 18th, 2024. And that case number is CE 2024-00147 with $0 in imposed fines. And that case was abated on September 19th, 2024. I have good service via posting on the property and posting at the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, findings of facts and order acknowledging compliance from previous case, CE 2024-00147. Exhibit B, photos taken during an initial inspection on June 25th, 2025, and photos I took during my subsequent inspections on July 2nd, 8th, 16th, 29th, August 5th, 12th, and photos from a final inspection on August 19th, 2025. Exhibit C, a copy of the repeat notice of violation and hearing sent to Edward A. and Erica Jules Furlong. A photo of the notice of violation and hearing posted on the property, and a copy of the general pre-hearing order, as well as a copy of the posting affidavit.
I'm starting to kind of do this. I think it's more useful for me to have a narrative up front on the case.
Yes.
So what's going on?
So there was a complaint that came in that they had a bunch of pigs on the property. So not me, but another officer went out there and took photos of it, and then the case was assigned to me. I went out there, saw that there was pigs as well as other debris on the property, posted the property with the violation. I did have contact with him and told him that everything needed to be removed, which he has removed most of it, but there's a few piles of junk still remaining on the property.
I noticed that in the prior case, I assume I presided over it, but in April of 2024, I found there's a violation, and then it was abated 5 months later, and it led to $0 in fines.
Yeah.
Did I give like 6 months to bring it into compliance or something?
Yeah, you gave 5 months. I was surprised but and confused by that too. So when I read the order, you did actually give
Wow.
5 months.
Okay.
You gave me 6 months.
Must have had
Oh,
a good
6 months?
reason.
Oh,
I must have
okay.
had a good reason. Why
Well,
did I
when
give
I-
you? Why did I give you so much time?
Because I had to tear down a building, a block building, and I just bought the property. And according, I didn't have a permit, but it was built in 1968, which when permits came into effect, it was 1986.
That's right.
So that should have been grandfathered in.
Hmm.
But I tore it down anyway. And then she's talking about my pigs. They kept escaping, so I built pig pens on the other property, which I thought I could do. I just couldn't have.
Did I order you to
structural-
take down a building?
Yeah.
Can I see the orders? Yeah, actually, can you show them, Mr. Furlong, and let me know if,
Yeah, tear down a building.
let me know if you have any objections to those documents, but I really want to read the order.
Yeah, this was all taken out when she told me I had to, because I work late, so I don't really have time to clean. But every time I got home from work, I'd do what I could, you know.
She,
And then I
she
have
said
to-
that there's
and then I-
mostly been improvement, but I just
Yeah.
want to see, I need
But
to see these
I had
documents.
to rebuild all these pens in the back of my yard, and that was not easy to do. And I'm trying to get rid of these pigs, but nobody wants them.
My wife probably does.
Your wife?
Yeah, she probably wants them.
Potbelly?
She
Take
loves
my
a good
name?
pig. She's married to me.
It's too funny today. Yeah, all this is cleaned up. I forgot my phone and, because I took pictures too.
Yeah, and that's fine. I just want to see these documents so I can look at them real quick.
I thought I could have a pig pen on my property. No. As I learned today, you can't even have a picnic table.
All right, let me see here. Okay, I remember this case. Yeah, I mean, just for the record, no one mentioned anything about that structure being built in 1968 and being grandfathered
I
in.
tried mentioning it.
Well, what you said was you had bought the property at a tax deed sale.
Yeah, I bought it at a tax deed.
Right. Okay.
And I guess somebody called and complained because of the building. I kicked out meth heads that were living on it and in that building, and that's the reason I bought that property, get rid of them.
I mean, so do you understand why this is a violation of the code? Why today?
I didn't think well, now I do.
Yeah, I mean, Ms. Wilkinson, can you explain it? I mean, the property has to be vacant unless,
Unless you have like a primary structure on it.
so as you just said, Ms. Furlong, it doesn't matter whether it's a bench or anyway. So anyways, I think I hear what you're saying. So part of the issue for you in being able to comply here is, being able to get rid of the stuff and animals, correct?
Right. Which
How
I
long-
did.
Yeah. It's all gone?
Yeah.
The photos, what remains to be done?
Cut my grass.
Oh, well, okay, so the only thing I see in the photos are some debris, some junk?
Yes. So there's three little areas when you're standing in the road looking at the property in the back left corner where it looks like a picnic table, there's some other debris there. Then in
That was removed.
the middle of the property where there's a huge tall pile of weeds, there's a pile of debris behind that. And then in the back right corner, there's something, I don't know what it is.
But you're talking about junk debris, correct?
Yes.
That was a lawnmower hood, which is removed. That big pile of grass you see is dirt.
Okay.
So
And
here's,
then over in the corner, that was all cleaned up.
Okay.
I still had leftover block from my block building I had to tear down.
well, from what I see on the photos as of yesterday, there's a very few items remaining. What is the county's recommendation?
$100 a day.
From,
Oh, sorry. To begin on the date that I posted the property, which is July 2nd, I'm sorry, $150 a day to begin on the day that I posted the property on July 2nd and continue until August 19th. That would be 49 days, totaling $7,350, and then a fine of $250 per day from this day forward until the violation is abated.
I admit exhibits A, B, and C into evidence. I can't argue with it. Is there anyone from the public who wants to be heard on this case? All right, Mr. Furlong, from July 2nd to August 19th, there's going to be a fine of $150 a day each of those days. And then from today's date forward, it will be $250 a day. So please call them when it's all done.
Doesn't that violate my Eighth Amendment right with excessive fines?
Do you think it does?
I do.
Why?
Because it's excessive.
Why?
$150 a day?
I mean, the range of the fines is up to $1,000 a day. The Eighth Amendment against excessive fines has been addressed in some of these cases, and I think actually in Indiana there was a case where there was a judge who was found that an excessive code fine did violate the Eighth Amendment. But in this case, I don't think it violates the Eighth Amendment because it's not something that deprives you of your property. So usually in these cases, it's considered an excessive fine when it's so large that it affects like an eminent domain style taking of the property. This isn't that. But if you do believe that, you can appeal my order within 20 days. I will issue the written order. Okay? Thank you.
Thank you.
Next case, Brittany Marie Stretchos, case number 2025-1045. Code Officer Cody McGuire, page 30 of your agenda. I apologize.
It's okay.
What page of the agenda?
30.
30. Oh, how do I pronounce that?
You pronounce every letter. Schreckengost.
Schreckengost.
Yeah. It's easier than it looks. I do. Thank you.
Okay. Good afternoon.
Good afternoon.
Thank you for your patience. Are you all the last of the...
Yeah.
I don't think they did it on purpose, but okay. Please proceed.
Okay. Cody McGuire, Citrus County Code Compliance Officer, case number 202501045, accumulation of junk and debris a violation of Chapter 20, Article 3, Section 2031A of the Citrus County Code of Ordinances. Address is 5665 West Paul Bryant Drive, Crystal River, Florida. Property owner is Brittany Marie Schregengast. Good service via signed certified mail return receipt and posting at the Canton Government Building. I'd like to authenticate the following documents and request to be admitted in evidence. Exhibit A, photos taken during initial inspection on June 19th, 2025. Corrective action inspection on July 9th, 2025, and photos of my final inspection on August 18th of 2025. And Exhibit B is a copy of the notice of violation, copy of the notice of hearing, copy of the signed certified mail return receipt, and pre-hearing order.
What's happening?
So, this property had a little bit of like construction materials, things set up for composting. They come a long ways, and what brought us here is they thought I was nitpicking. And the only thing that remains now is just a little bit of construction debris that they planned on removing, but weather had interfered with that. And there's a few other odds and sods that are on the driveway, including like an old bent metal rack on top of a little outside storage container. There's other wheels and...
So what you're saying is it's a junk case, there's been a lot of improvement, there's not much left. You
Correct.
may even disagree about what remains to be done.
Correct.
Okay. Then could you please show the exhibits? And ma'am, take your time and let me know if you have any objection to them being evidence in this hearing.
Oh, that's the trailer with all the...
Yeah, when it was all moved.
Oh.
Yeah.
Oh, okay. That's it.
That's all the notices.
Wait, there's no... That's it? That's all the pictures?
Yeah.
For exhibits.
Yeah, from the first time, the second time, and then from
My first inspection, corrective action inspection.
Where's the accumulation?
We're
This
gonna
is-
go over
but
that.
that's not what I want. I want to know if you have any objections to them being evidence in this hearing.
No.
Okay, thank you. All right, so without objection, what's been proposed as exhibits A and B is evidence. And just before you proceed, Mr. McGuire, I'm going to take a quick look just so that I understand what's going on, where y'all have been and where it's headed. You wouldn't think I would have to move my head so much just to look at a photo, but the reason is the glare from the lights. This is interesting. Okay. Okay. I'll let you conclude and present your case.
Okay. On June 19th, 2025, I conducted an initial inspection and observed the property to be in violation. A notice of violation was issued for junkyard conditions, which is a violation of the ordinance listed above. On July 9th, I conducted a corrective action inspection and observed that the property had remained in violation, although progress had been made. And as of my final inspection on August 18th, the property remains in violation. I've had contact with them throughout. We did play a pretty sad game of phone tag for a little bit, but we did come in communication.
Okay. Ma'am, what's going on?
Yeah, so I guess it's the general idea of what constitutes junk, because I know we cleaned up a lot that he had recommended, which the first time he came out, we had just gutted our bathroom, so a lot of it was out front, but it was only there for maybe 2 days before it was gone. So by the time we even got the notification, that had already been removed, because we know around this time that we're gonna get some kind of notice, because it's happened for the last 3 or 4 years. So we cleaned it up. We asked him to come back, take a look again. He asked about containers and stuff like that. So we picked up whatever he mentioned, thinking we were okay. He came back again this last time with wood that needed to be burned, which is really not a lot. And yeah, it rained the night we were supposed to burn it because we burn it at night. So it's on the schedule to burn today. We actually run like a community education for composting for the community. We call it CORI, Community Organics Recycling in Crystal River. So we do a lot of composting on the property, which is why we have bins full of compost or vermicompost, because we also do worm composting. So we didn't think it was junk stuff, the small things that were on top of the storage container that continues to keep us in violation. We see that as unfair because we have cleaned up so much. And to be nitpicky about stuff like that, that's what feels nitpicky, because he says, there's stuff on top of the storage bin, little tires because we had to fix a cart. A cloth that was in the driveway. So we work so much in the yard and around because we're constantly growing things that.
Let me tell you why, just so we can be on the same page.
Sure.
That I know it feels nitpicky. The reason why legally it's not nitpicky is that if it is technically a violation, it's not cleared up at the time, and then you get cleared. You're going to hear something like what the Darmientos said, which you were here for, and say, hey, you said it was okay to keep that cloth in the driveway. You said it was okay to. So that's why in this instance, I totally, but from a legal perspective, what we can't have is a situation where the county wasn't clear about what was offending and then it wasn't resolved. That's all. So I'm not trying to cut you off. I just want you to understand where I might back them up on that.
Sure.
It doesn't sound like y'all actually have a problem in cleaning this out.
No, well, and we don't accumulate junk. Like the very first time we got cited, for sure, because we were like trying to salvage junk. But ever since then, we've done our best to make sure we're not accumulating junk or keeping a dirty property, because we do deal in compost. We have to stay clean. Well, I see, for example, on photos taken on Monday, I'm not sure if I'm reading this right, but it looks like you have not one, but 2, or maybe even 3 no trespassing signs on the, I mean, how many do you need? I don't know. I don't know how many are up there. They get stuck up there.
I mean, but they're all in the same spot. They're all like the same sign. So, I mean, I think this just requires some choices or some storage, For example, like, the boxes, there's some stuff on top of the lid that, you're not allowed, like tires, things like that.
They're plastic tires for a cart.
But they're not on it. That's gonna run you into trouble.
But it's stuff like that where it's not there continuously, but as we're moving through the structure, doing things and cleaning things up and fixing things, and he shows up at the time when we just laid down something, and then now we're still in violation because we laid that thing down.
That's right.
At an inopportune time.
Right. So look, my job here then is to give you a sufficient amount of time to bring it into compliance, no questions asked, right? Okay. So what I want to know from you is, how much time do you think you need, given the fact that Mr. McGuire is going to be a hawk on it?
Well, based on the items that he indicated were junk, it's already been cleaned up.
Okay, so you don't need much time.
Well, except for the wood, because we still have to burn that.
Is 14 days enough?
Yeah.
Mr. McGuire, is there any reason you have to believe that 14 days isn't enough to bring this property into compliance?
No, sir.
It looks like enough to me. I mean, this is...
Yes, sir. We spoke yesterday about it too and came to an agreement.
What's the county's recommendation?
It would be $100 a day after that.
Is there anyone from the public who wants to be heard? Yeah. Okay, yeah.
Sorry, I'm just chomping at the bit.
Sure.
So yes.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Help me God.
Please state your name.
Christopher Sengelop.
Come on up to the microphone if you would.
Yes, sir. So,
sir, how do you spell that? I think she asked.
Sengelaub. No problem. It's beyond like a definition of junk anymore, because it's not like everything when he comes out is just me working that day. And so it's got me, like as a resident of my own house, I can't go work in my driveway for fear that Mr. McGuire is going to come around the corner with a camera and violate me for what I'm working on that day. Like the wheels were out on a cart. I didn't put the wheels on the cart because they didn't fit, right? But if he came back the next day to verify if they were in a container, were gone. Because none of the stuff is there the second time, third time. Anytime he comes out, it's always completely different. There's no accumulation going on whatsoever. And then he would start to turn to vegetation pile. Well, it's the carbon for my compost. And so it just, instead of it being like, all right, everything looks good, it was, let me really try to find the violation. And it was, even so, like I had my trailer one time, and this was, and everything loaded up on it, and I'm like, whatever needs to go, tell me, and I will get it out of here right now. I just want this to be over. I'm trying to work with you guys. Whatever we can do. Sorry, can't do it. But this is all out. Everything else is good. But now my trailer with all of the stuff that I'm taking to the scrapyard, that's now the new violation. And it's like, I get emotional because it's my house. None of my neighbors are complaining. The only complainant since the very first one is Mr. McGuire. He's the only one. All of my neighbors know what I'm doing. None of them are telling, hey, you got a junkyard or anything.
Do you have a complaint for this case?
Yes, sir. Excuse me, we're 100% complaint based.
Right. But I'm just saying you do have a complaint on this.
Yes, sir. You can do a public record request and find out.
Yeah, so you can find out. What you do is a public records request.
We did. They're not there.
It shows him as the complainant.
He's the only complainant on here. All of our paperwork shows it's only him.
The complaint came from road maintenance for an obstruction or right of way.
Okay.
So, but
came from the county.
But they were the ones that left the mulch there. But anyways, that's a whole different thing. That has nothing to do with the accumulation of junk. There was the right of way passage, and it was because I had.
Well, sir, you're here for public comment, so I shouldn't have interrupted. I should let you say what you need to say.
Sorry, it's that it's just a normal person trying to work at their house. It's not an accumulation of junk or debris or anything at this point. It's just me. I've got tires out because I'm working on this, or I'm working on my Jeep. It's just like nothing's left there. Everything is inside the receptacles. It needs to be.
Well, I do see some things that have been there now for quite some time. So, for example,
go ahead.
I'm not sure if this is on the property or not. Now that I'm thinking about it,
Probably not.
What's this Nestle ice cream thing?
That is a vermicompost bin for pet waste.
Is it?
Yep. Yeah. That's for the neighbors.
So
to be
is
able to
that
drop
that's
there.
not considered junk under your case?
In the county's eyes, that would be junk. It's a refrigerator case.
So I'm just, composting is the exception to all of these inside the code. For commercial or residential use, if it's for compost, it's an exception. And that is a vermicompost, the best kind. And it's for public use.
Saracen?
It was repurposed as a bin, it's not.
Okay, I'd be curious. We need to figure that out, I think. I don't want to.
That's actually what I've done several times, is asked for clarification,
Sir,
and they
just
can
hold
never
on.
give it
I
to
was
me.
talking.
Sorry,
No,
sorry,
that's-
I apologize.
I know it's your property. But yeah, so I don't want to issue an order regarding finding that something's junk if it is excluded under the code. I do know that there are counties and cities out there that do have code sections about composting and
Well, it doesn't say what bins can be used. If it was repurposed as a bin, we're not
Says
using it
appropriate
as
place,
a
but
function
doesn't
for a
specify
cooler.
appropriate place. So
Yeah.
I keep records of all of my compost piles. I have to. I've got containment plans to make sure. I've done everything I possibly can to make sure that whenever I need to work with, I can work with
Yeah,
it. That's why.
part
this
of our
point, I wanna say
education
that
for
I
the
feel targeted.
Part of the education for the community is to use what you have, even if it is junk to a degree. So it's function over aesthetic to some degree. Waste diversion. So if it's what they have, we want to show that you can use it. So that's part of why we tend to use bins that are not normally.
Or a wheelbarrow that has a broken handle still works.
Sir, if you
as a
would,
wheelbarrow.
I know that you're passionate, but I saw you shaking your head literally the entire time, Mr. McGuire, so I don't like that because I can't focus on, so if you don't mind, please sit down. Thank you. Ma'am, can you please finish what you were saying? You were talking about, I think you guys called it waste diversion, and
Yeah, it's to teach the community about composting and using what you have. So we show that when we have workshops on our property, we show that you can use what you have. And so it's functional in the sense of composting.
Okay, so I mean, that may or may not be an issue. And it is true that if someone is working out in the front lawn and is, simply dealing with some stuff, then that is not a violation of the junk section. But what does violate the junk section is if something's out there for more than 48 hours.
Right.
So, Ms. Harrison?
I see the nuance where they might disagree. Within the definition of junk, it says it shall not include compost piles. Since it's in a container, the container is considered the junk by Mr. McGuire. The pile would not be considered junk. So I believe that's the nuanced distinction that has got us here today.
It also contains for animals.
I don't think so. I think we're here because of mostly non-composting stuff.
Correct.
Yeah, so, but now I'm concerned about the composting, and I'm making this an issue, so as I want to do, I'm making it more complicated than it needs to be.
Under the definition section 20-3.
20-3?
Correct,
Right.
the definition of junk.
Oh, brother.
So based on that, the county's position is they can have a pile of compost. They can have it for commercial purpose even. These
Let me
junk
ask you this.
containers are junk.
Let me ask you this. On a compost, let's talk about the Nestle ice cream thing in particular. Like, what's inside of it?
It's dirt and worms, and it's for composting pet waste.
And does it need to be outside?
Well, it's so the community can drop their pet waste in it. So in the function of it being accessible to people walking their dogs and dropping their poop in, yeah. But otherwise.
This is getting more complicated because it's interesting. The code does exempt compost piles. So let me just, I want to talk through how this works with you because I'm not an expert on compost.
Yeah.
Let's say that the stuff wasn't in the container. I mean, are you able to have just a pile there and then people don't, like, what's the purpose of it being in a container?
The worms.
The worms.
To contain the worms, so to create vermicompost and break down the pet waste. Otherwise, it's a worse process. You have to be more manual with it. So the worms take out that manual process of having to actually be
It
involved
also
in.
protects the worms, I imagine.
To a degree, yeah.
What I'm encountering in my legal analysis here is that I don't see a specific, and please let me know if I'm wrong, but I don't see a statutory exception for the containers. I see a statutory exception for compost piles. Like, it's unarguable, it seems to me. Now, there is additional language here. It talks about compost piles for normal, personal, or commercial use in their proper location. Well, but it doesn't say community use. It doesn't say everyone's pet poop.
So-
It says normal, personal.
Right.
or
But what is
commercial.
proper location?
That's a good question.
Because
I know.
if I think it's a proper location to keep it there where it can be accessible,
We're a community compost.
yeah.
I'm it's a business. The compost. That Nestle bin. You guys, they pay for it, or who?
They don't.
You tax people.
I don't have to because it's an agricultural product on my land. So it's the worm castings that come out of there are sold.
The worm castings are sold. That are a
The
result
worm
of.
castings. What is a worm casting?
It is worm manure.
Well, ma'am, you're on the microphone.
Oh.
Do you want to defer? I bring him up. He's a member of the
He's-
public, so I have to.
Yeah, he's got the community compost certificate. So
Okay,
he's
sir,
the ones
why
with the
don't you
science
come up?
behind it.
We're gonna get into this. So, what is a worm casting?
Worm casting is essentially worm manure. It's passed through the gut of the worm, which bio-oxidates it and basically turns it into the best organic fertilizer on the face of the planet. All organic, there's no chemicals involved. It's basically what the EPA is begging everybody to do. I'm just trying to do it on a little bit bigger of a scale because not everybody can do it. And it's something that I'm hugely passionate about because it prevents unnecessary things going to the landfill. There's just so many public benefits, and it's also retaining resources. So it's strengthening the food system.
Here's where I'm coming down. I'm convinced of the viability of what you're saying, commercially even perhaps. But the code, to me, is pretty clear. You can have compost piles. I don't think you can have compost piles in junk.
Well, but it states you can have them in bins. And so
Where's that? I mean,
in your ordinance and on your website, it says you can have bins and then to find bins that are appropriate for you.
that's what I want to know, because if I can find that, I can.
Yeah, it's on your compost website. The web compost portion of your website.
Yeah.
Of the county website?
The county website, sorry, not your website.
I'm gonna look it up.
We were trying to find all of the, like, where is an appropriate place? We actually
Yeah,
asked
we're
for
not,
guidance from Cody.
yeah, we're not trying
They
to
couldn't tell us anything.
bend rules or anything. We want to stay compliant.
100%.
But we also want to show the community how they can function with things that they have laying
We're
around.
not trying to get away with anything. We're just trying to exist, be able to have a viable organic business that actually benefits the community, and that's what the whole work.
Okay, I see the composting website. I do see,
It said piles or bins.
Piles or bins. Because a vermicompost bin is
choose the right location for your compost bin.
And
Maybe they give them out. Orange County does. I don't know.
they do in Marion, but not in Citrus. No.
I see.
There's really no
To build a compost
infrastructure
pile, simply
in Florida.
alternate layers of browns and greens. They specifically talk about doing it in bins. So just for the record, I'm reviewing the Citrus County website on composting. Home, departments, community services, extension services, green living, composting. That's the path to get there.
That's also the issue with a lot of.
I don't see an ordinance about it, though. I mean, this.
Oh, no, it's not an ordinance, it's the city's recommendations about what to do with the compost. That's the only reference we have aside from where it says that compost is an exception, is to go by what else the county says about compost. And so we're kind of
I'll tell you, the guide star for my decisions is the code. So I'm open to hearing this. What I'm really interested is if the county has some kind of regulation. Well, I really want to ask Ms. Harrison and Ms. Katu. I mean, are y'all familiar with the county's position on composting, besides, I guess, it being something that they like?
With regards to the code, we only have compost in the definition section creating that exclusion. There is no other, so I did a quick search. I cannot locate another section within our Citrus County code that allows for composting in the way you're describing, in the manner you're describing, where you have a specific exception permitted.
Have you seen the composting website?
I was looking at it as you were reviewing
It's
it.
interesting.
It does, at this point.
I don't know if it was cleared with the county attorneys.
At this point, we would argue that the stuff out there doesn't qualify for anything outside of junk. Proper location could be a shed. You can put your worms in their container from your freezer and put it in the shed. But at this point, we don't have any other item.
It's got a lid. What would the container need?
Yeah, I mean, I think that thing standing by itself is junk. It's something that's normally inside
Yeah, by
anyways,
itself,
right?
it's repurposed into being a vermicompost bin.
Now,
for the public.
However, yeah, but it does seem to satisfy the statute of junk. I understand why you're using it. You might have a lot of support for it.
Does junk have a purpose?
Junk could, but I mean...
But like a daily usable purpose that everybody gets to use, it's like junk would definitely not be something that actually has public use, right?
Not usually.
This is something that has
Not
public use.
usually, but I mean, you could take there's all kinds of things that could end up, like a discarded tool. So if you read the definition of junk, it's abandoned property, construction and demolition debris, litter, waste materials of any kind, unserviceable automobile or machinery parts, used or non-functional furniture. So it could even include used furniture. Because what normally happens is it's something that, like, maybe you've got a couch, but it's outside. A couch shouldn't be outside. So that's used furniture, it's junk. Same thing. I'm not saying that you can't use this thing, but because it's outside, it's in a place that it's not normally used, it by itself would be junk. And your compost pile is fine by itself. All your compost piles sounds like they're fine, but not inside of the stuff if it's outside and if...
That this has been here I apologize.
Well, that's irrelevant.
Okay,
So
'cause it's
it's
literally
totally
past
irrelevant. There's
inspection all the
no
way through.
free, whenever it comes to the county's attention, it comes to the county's
Well, it's
attention.
Can I,
right
can
there
I
in
ask a
front of our
question?
property.
Yeah, really. Because if it didn't look like a cooler, right? So if the electronics were torn out of it and it was spray painted and it just looked like a box, would that,
No, because imagine it's a cardboard box. I mean, that's the
Yeah.
perfect, we just had a case where there's cardboard box junk out there.
It's just, it's really stretching the definition of junk to reach over this rather than the other way around. Like,
No.
it could go both ways, but we're stretching it over to
Imagine that
junk
you
side.
have a perfectly functional refrigerator,
Mhm.
and you just put it on an extension cord and you put it into your front yard, no cover, anything like that. It's going to become junk very quickly. But it may not be on day one. I mean, I
This has been here
guess
for 4 years.
theoretically, under this definition, you would have the right to, well, it says used or non-functional tools, equipment,
But it's
and implements. So even if you have a hammer that's usable and used by everybody, but you leave it in your front yard, it's junk.
But it's being used.
Yeah, that's what I'm saying.
But it's being used.
Actually,
like-
used is in the definition here.
What I mean, like, it's in use.
Used is
so,
in
so
the
is it just
definition.
the fact that it had electronic components in it that's not functional that way? Like it's not functional as a freezer, so that's why
Well, it
it's
says
considered junk?
non-functional. Here, that's also in the definition. So
Here's my
things that
other
are
thing.
non-functional, things that
If
are used.
I just can get rid of the
Mr.
vermi
McGuire, let
compost
me ask
bin.
you a question. So is this the only compost pile issue that we have here, or are there other bins or stuff? I just want to be clear for everybody, whether I'm right or wrong.
You referring to the 2 piles out on the property?
Well, I assume that those piles are fine. Yeah, we're not talking about those.
No.
So I brought up the Nestle
Mhm.
container. Are there any other containers that you think are illegal under the code?
Just things that are not stored properly. A lot of them would be like under the tarp to the left of the house. I believe they're black
Well,
little.
what's the blue bin? What's that? Is that a compost bin? The blue? There's a blue.
That's actually that's a Halloween decoration.
If you can't get to the microphone.
No.
Sorry, I just
no,
want you.
Yeah, that's,
I literally just brought that from that day I had found it. I brought it up. Now it's repainted with Frankenstein's face on it. And it's going to be used as a Halloween decoration. Right now it's sitting on our back porch, but literally that was the day I had brought it.
Okay.
Yeah, sorry. I have a temporary fence there, so I wasn't able to get it past it. So that's what I mean. I'm just living my life trying to do my
and
Halloween
and
decoration.
repurposing. We
But now it's
trying to
a
be
vi-
thrifty, yeah.
If it was anybody else, it wouldn't be a violation. He'd just be driving by. But because it's me, I get a violation and then have to do all this other stuff, all because I wanted a Halloween
I
decoration.
don't think the code allows you to take what would otherwise be a piece of junk and to put a compost pile in it. Whether I think that's right or wrong is besides the point. I think that Attorney Harrison's analysis is correct, that under the definition of junk, it is junk, regardless of what's in it, okay? In other words, it could be, if it's empty, we don't even argue about it. If it's got a bunch of other stuff in it, but the thing is that the thing itself is junk. You're not allowed to have that container out there.
What would be an appropriate container for a vermicompost?
It says and I'm only going to say this one more time. So in the definition of junk, it allows compost piles for normal, personal, or commercial use in their proper location. I encourage you to retain legal counsel to give you the advice you need if you do want to keep it out there in anything other than the other kinds of piles that you have. I have no issue with those. Or you can lobby the county commission to amend the code. Create new exceptions and stuff like that. So I am going to find that the property is in violation. I'm going to grant, is 14 days still enough, do you think, to bring it into compliance?
If we could have, I've got to figure out what to do with all of those worms that are in there, which are also a valuable source.
That's why I'm asking.
A pound of worms
That's why I'm asking.
goes for $50. And so I've never had to relocate.
Is 30
all of
days
those.
enough?
I don't think so. Just, I gotta sell them.
But you can just put them in the garage. You can put the whole thing
I
in the
already
garage.
have 1 million worms in my garage. This was a pet waste one that I did for the community because all my neighbors use it. That's why nobody's complaining about it. Everybody's using it. That's why it's good. The only person complaining about it is Mr. McGuire.
It's just got to be in an enclosed building, and I don't think it's going to take more than 30 days to move it. So, I mean, I'm willing to give you reasonable time, but I mean, I'm not going to do more than a month. What's the county's recommendation again?
$100 per day.
All right, guys, I'm going to give you 30 days, and it'll be $100 a day if it's not brought into compliance.
And,
Thank you.
For appeal, we need the
You've got,
record.
I'll issue the order, and again, I encourage you to speak with legal counsel. No, but there's a
retainer.
specific section, and it'll be in the order, okay?
All right,
Good
thank
luck.
you so much, and thank you for your patience.
Sure.
Really.
Next case, Brittany Renee Blanks, case number 2025-893, Code Officer Alan Jonason.
Good afternoon. Alan Jonason, Citrus County Code Compliance Officer. You did? Wow. 4 cases ago. It has. I've had a birthday. Case number 2025-00893, excessive growth and accumulation of vegetation, a violation of Chapter 20, Article 6, Section 20-60 of the Citrus County Code of Ordinances. The address is 3439 South Fairway Terrace, Inverness, Florida. Property owner is Blanks Brittany Renee. Property is .40 acres, zone CLR, and was purchased January 2024. I have good service via posting the notice of hearing on the property and posting at the Lecanto Government Building. I'd like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on 10 June 2025. Photos from my compliance inspection on 24 June 2025, and photos from my final inspection conducted on 19 August 2025. Exhibit B, copy of the notice of violation, copy of the notice of hearing, a photo of the notice of hearing posted on the property, a copy of the pre-hearing notice, and a copy of the posting affidavit.
Thank you.
On 10 June 2025, I conducted an initial inspection and observed the property to be in violation. On 10 June 2025, a notice of violation was issued for lawn, which is a violation of the ordinance mentioned earlier. On 24 June 2025, I conducted a compliance inspection and observed that the property remained in violation. I have had contact with the property owner's brother, and as of my final inspection on 19 August 2025, the property remained in violation.
And what did you learn from the contact?
So evidently, the property owner has some health issues, hadn't been able to, the neighbors actually cut the lawn, thinking they were doing a good thing. The tree debris, however, is still there. The property owner's brother did say he would have that removed in the next couple days and would call me and let me know when he was ready for inspection.
What's the county's recommendation?
$50 per day, along with the administrative costs.
Okay, I will grant 20 days, and it'll be $50 a day.
Thank you.
Next case, Dale Eugene Bramel, case number 2025-937, Code Officer Julie Wilkinson, page 9 of your agenda.
Case number 00937, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is 3440 North Burroughs Path in Beverly Hills. The property owner is Dale Eugene Bramel. I have good service via posting the notice of hearing at the property and at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during an initial inspection on June 13th, 2025 photos from a corrective action inspection on July 1st, 2025, and photos of my final inspection conducted on August 19th, 2025. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, a photo of the notice of hearing posted at the property, and a copy of the posting affidavit.
Thank you. Exhibits A and B are admitted without objection. Did you take the photos on the dates indicated?
Yes.
What's the county's recommendation?
County's recommendation is, well, actually, the property is in compliance as of now, but I've had 3 complaints on this property in the last 3 months, so I decided to bring it to special master even though it's already abated.
I see. I understand.
Yes.
Is there anyone from the public who's here on this case? All right, I find that the property was in violation and will assess administrative costs.
Thank you.
Thanks.
Next case, Inz Burke, case number 2025-896, Code Officer Erica Olson, page 11 of your agenda.
This is case number CE 202500896, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20, TAC 31 Alpha of the Citrus County Code of Ordinances. The address is 5719 South Chamberlain Pool Avenue in Homosassa. This property is vacant, 0.30 acres, in zone CLRMH. Property owner is Inz Burke. I have good service via posting on the property and posting at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on the 3rd of June, photos of my compliance inspection on the 24th of June, and photos of my final inspection conducted on the 18th of August of this year. Exhibit B, a notice of violation, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, a copy of the photo of the notice of hearing posted on the property, and the posting affidavit.
Okay. Then they'll be admitted without objection. And I don't see any other members of the public who end up wanting to speak, so I'm not going to ask about the public anymore. These are exhibits. It's a junkyard conditions case. Did you take the photos on the dates indicated?
Yes, except for the posting affidavit. My director posted the property for me.
All right. Now, looking at the photos, it doesn't, I mean, it's the stuff under the tarp and the concrete blocks and that
Yes,
kind of
so
stuff?
this property had an unsafe structure case. He burnt down the home that was on the property, and the junk is the remnants of what's left on the home that need to be removed.
Got it. Have you had contact with the owner?
I have had contact. He said that he gets his check on September 3rd, and he will be able to have the junk removed then.
Okay, then I will grant 21 days from today. Find the property in violation. If it's not brought into compliance as ordered, what's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $100 per day in
$100 a
administrative
day.
cost.
Thank you.
Thank you.
Next case, Carlson, case number 2025-996, Code Officer Cody McGuire, page 14 of your agenda. Expert on the case, Land Development Director Joanna Coutu.
Go ahead.
Cody McGuire, Citrus County Code Compliance Officer, case number 202500996. Special requirements for all accessory structures, a violation of Citrus County Land Development Code 3102A. Address is 2927 North Oakland Terrace, Crystal River, zoned RURMH, and it's 0.33 acres. The property owner is Carlson. Good service is posting the notice of hearing at the property and posting at the Canto Government Building. I'd like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during initial inspection on June 23rd, 2025. Corrective action inspection on July 8th, 2025, and photos of my final inspection on August 18th of 2025. And Exhibit B is a copy of the notice of violation, copy of the notice of hearing, copy of the photos of the property posted, a pre-hearing order, and a posting affidavit.
Okay. The proposed exhibits are admitted as evidence. Okay. This is a parcel that is supposed to be vacant,
Yes, sir.
and it appears that it's got some junk on it.
Yes, sir.
So you took these photos on the dates indicated?
Yes, sir.
How many cats are on this property?
You know, I haven't seen a cat, but I've seen a rabbit.
There's a cat in one of your photos.
Is it really?
Yeah.
Oh.
I mean, that's not a rabbit. All right. That's not,
What color is the cat?
If
'Cause
you
the
think
rabbit
that's
was
a
brown.
rabbit, man, you gotta really.
No, I know.
What do you think that is?
That is definitely a cat.
Oh, okay. All right. Just checking. Just.
Never seen it before.
You didn't know you were taking a photo of it. It was blending in.
Yeah.
Well, it's a nice cat.
It looked adorable.
It's living the dream. All right. Well, what's the county's recommendation?
$100 per day per standard.
Okay. 30 days, $100 a day.
Next case, James Avoy III, case number 2025-594, Code Officer Erica Olson, page 16 of your agenda.
I'm sorry, I took a little snack and I'm just trying to chew it. This is case number 202500594, accumulation of junk and debris, violation of Chapter 20, Article 3, Section 20, Tac 31 Alpha of the Citrus County Code of Ordinances. The address is 8276 West Amelia Court, Homosassa, 0.27 acres zoned LDR MH. Property owner is James Avoy III. I have good service via signed certified mail return receipt and posting at the Canto Government Building. At this time, I'd like to authenticate the following documents and request that they be admitted into evidence. Photos taken during my initial inspection on the 24th of April, 2025, compliance inspection on the 9th of May, photos of my subsequent inspection on the 11th of July, and photos of my final inspection on the 18th of August. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, and a copy of the signed certified mail return receipt.
Okay. What's been proposed as exhibits A and B is evidence. Thank you. All right. Did you take the photos on the dates indicated?
Yes, I did.
It's an older case starting out in April.
It is. I did go out there. I made contact with the owner. He had asked me for additional time, which I granted. As of my inspection on Monday, it's still in violation.
Have you had any other further contact with the owner?
No, I have not.
Okay. What's your recommendation?
The county recommends $100 a day along with administrative costs to begin after the date you deem appropriate.
How much?
100.
14 days, $200 a day.
Thank you.
Next case, Fifth Seven Construction Group LLC, case number 2025-558, Code Officer Julie Wilkinson, page 17 of your agenda. Expert on the case, Land Development Director Joanna Coutu.
Case number 00558, special requirements for all accessory uses, a violation of Citrus County Land Development Code 3102A. The address is 2192 West Deerfield Lane in Citrus Springs. The property owner is Fifth Seven Construction Group, LLC. I have good service via signed certified mail return receipt. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during an initial inspection on June 12th, 2025. Photos taken during a corrective action inspection on June 27th, 2025. And photos of my final inspection conducted on August 19th, 2025. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, and a copy of the signed certified mail return receipt.
The proposed exhibits are admitted as evidence. Yes. So this is one where they had a permit to build, permit expired, they haven't finished.
Yes, exactly, and no CO is issued.
Okay. What's the county's recommendation?
$100 a day.
Okay, I'll do 60 days, $100 a day.
Thank you.
Next case, Nicole Groonike, case number 2025-916, Code Officer Cody McGuire, page 19 of your agenda.
Cody McGuire, Citrus County Code Compliance Officer, case number 202500916, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. Address is 8215 West Woodbury Court in Crystal River. It's .30 acres and it's zoned MDR-MH. The property owner is Nicole Groonike. Good service via posting the property and posting at the Kendall Government Building. I'd like to authenticate the following documents and request that they be admitted in evidence. Exhibit A is photos taken during initial inspection on June 10th, 2025, corrective action inspection on July 7th, 2025, and photos of my final inspection on August 18th of 2025. And Exhibit B is a copy of the notice of violation, copy of notice of hearing, a photo of the notice posted on the property, and a pre-hearing order.
Okay. What's been proposed as Exhibits A and B is evidence. And did you take the photos on the dates indicated?
Yes, sir, I did.
All right. Did you say you had contact with the owner?
I didn't have contact with the property owner, but I did have contact with a woman that was staying there, and her name was Jennifer.
Okay. And what'd she say?
She stated that the neighbor had a shed that was filled with that debris, and the shed was being repossessed, and she stuck the debris on their property.
The neighbor stuck the debris on their property.
Yeah.
Okay. Well, seems like it's been there for quite some time.
Yeah, looks like they tried to burn the fridge multiple times.
What's your recommendation?
That one's $250 a day.
All right, I will do 14 days, $250 a day.
Thank you.
Yep.
Next case, JHH Real Estate Investors LLC, case number 2025-1024, Code Officer Erica Olson. Page 22 of your agenda.
This is case number CE 2025011024, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20, Tac 31, Alpha of the Citrus County Code of Ordinances. The address is 4411 South Chirper Drive in Lecanto, Florida, .26 acres, zoned AGR MH. Property owners JHH Real Estate Investors LLC. I have good service via signed certified mail return receipt and posting at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on the 26th of July, 2025, compliance inspection on the 16th of July, 2025, and photos of my final inspection conducted on the 18th of August, 2025. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the sunbiz, and a copy of the signed certified mail return receipt.
Right. The proposed exhibits are admitted as evidence. They will be Exhibits A and B. Did you take the photos on the dates indicated?
Yes, I did.
Okay. And have you had contact with the owner?
I haven't had contact with the owner, but I have had contact with the tenant.
Mm-hmm.
He basically stated that the items are outside because he has recently moved into the home.
Well, it's been months now,
Yes.
right? I mean, when did you have contact with the tenant?
It was after my corrective action inspection on July 16th.
What's your recommendation?
$100 a day in administrative costs.
14 days, $100 a day.
Thank you.
Jots Enterprises, case number 2025-420, Code Officer Cody McGuire, page 23 of your agenda.
Cody McGuire, Citrus County Code Compliance Officer, case number 202500420, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. Address is 6391 West Tangerine Lane, Christopher, Florida, 0.16 acres, and it's zoned LDRMH. Property owner is Jots Enterprise, Inc. Good service via posting the property and at the Lecanto Government Building. I'd like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during initial inspection on March 20th, 2025. Corrective action inspection on July 24th, 2025. A subsequent inspection on May 23rd, and my final inspection on August 18th. Exhibit B is a copy of the notice of violation, copy of the notice of hearing, a photo of the notice of hearing posted on the property, and a pre-hearing order.
The exhibits are admitted as evidence. Did you take the photos on the dates indicated?
Yes, sir, I did.
The case started in March.
Yes, sir, that one slipped on the cracks and was my fault.
Okay, no, I'm just curious if there was a reason, you know, like maybe you're giving them time to comply or something like that, but it looks rough. I mean, on the junk scale, it's tough. And have you had contact with the owner or tenant?
Yeah, several tenants. They say they're gonna get cleaned up, but every time I go back, it's somebody new.
Yeah, it doesn't look good. All right, what's your recommendation?
That one's $300 a day.
Okay, 14 days, $300 a day.
Next case, Kathleen J. Shell, case number 2025-1014, Code Officer Julie Wilkinson, page 33 of your agenda.
This is case number 01014, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is 9065 North Sapanaria Drive in Citrus Springs. Property owner is Kathleen J. Shell. I have good service via posting the notice of hearing at the property and at the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during an initial inspection on June 25th, 2025, photos from a corrective action inspection on July 10th, 2025, and photos of my final inspection on August 19th, 2025. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, and photo of the notice of hearing posted at the property, as well as a copy of the posting affidavit.
All right, what's been proposed as exhibits A and B is evidence. Junkyard conditions case, did you take the photos on the dates indicated?
Yes.
Contact with the owner?
No.
Any reason to think they vacated the property? No, I see some changes.
Yeah, there's changes. Mostly they just move the junk from the front to the back.
Mm. Yep, okay, what's your recommendation?
$100 a day.
7 days, $100 a day.
Thank you.
Next case, Jeremy and Kathy L. Taylor, case number 2025-941, Code Officer Alan Jonason, expert on the case Joanna Katu, page 38 of your agenda.
Alan Jonason, Citrus County Code Compliance Officer, case number 2025-00941, special requirements for all accessory structures, a violation of Citrus County Land Development Code 3102, address is 7920 East Wisp Trail, Inverness, Florida. Property owners are Taylor Kathy L. and Taylor Jeremy. This property is 0.25 acres and is zoned CLRMH and was purchased on 14 March 2024. I have good service via posting the notice of hearing on the property and posting at the Lecanto Government Building. I'd like to authenticate the following documents and request they be admitted into evidence. Exhibit A, a photo taken during my initial inspection on 24 June 2025, photos from my compliance inspection on 16 July 2025, photos from 6 August 2025, which is the date of posting the property showing additional items on the property, and photos from my final inspection conducted on 19 August 2025. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, photo of the notice of hearing posted on the property, copy of the pre-hearing notice, and a copy of the posting affidavit.
All right. The exhibits are admitted as evidence.
On 24 June 2025, I conducted my initial inspection and observed the property to be in violation with a truck and other junk and debris on the property. On 24 June 2025, a notice of violation was issued for special requirements for all accessory structures, which is a violation of the ordinance I mentioned earlier. On 16 July 2025, I conducted a compliance inspection and observed that the property remained in violation. While posting the property on 6 August 2025, I observed an additional boat and another vehicle on the property and have included a copy of that photo in Exhibit A. I have not had contact with the property owner, and as of my final inspection on 19 August 2025, the property remains in violation.
So I'm just curious on a case like this. So I've read the affidavit. I understand why you posted. Y'all tried to mail it?
Yes.
And what, was it just not like picked up or?
Never signed for.
Never signed for?
Yes, for.
Okay.
We send everything certified now.
Gotcha. The address on the pre-hearing order lists the address, you know, for the property, which is 7920 East Wisp Trail. And what is the address of where they live or what they're, do you know?
I think it's on.
Oh, I see it. 1861 North Bud
It's right near
Terrace.
there. It's right near there. Bud Terrace is near there.
Okay. What's the county's recommendation?
$150 a day, along with administrative costs.
Okay, 14 days, $150 a day.
Thank you.
Next case, WPRE Ventures 1 LLC, case number 2025-864. Code Officer Cody McGuire. Joanna Katu is the expert. Page 40 of your agenda.
Yeah, please.
I'm sorry. Cody McGuire, Citrus County Code Compliance Officer, case number 2025-00864, special requirements for all accessory structures, a violation of Citrus County Land Development Code 3102A. The address is 7684 West Rainbow Street in Dunellen. It's zone CLR and is 0.48 acres. The property owner is WPRE Ventures 1 LLC. Good service via posting the property and posting at the Canto Government Building. I would like to authenticate the following documents and request they be admitted in evidence. Exhibit A is photos taken during an initial inspection on May 30th, 2025, corrective action inspection on June 23rd, and photos of my final inspection on August 18th of 2025. And then Exhibit B is going to be the copy of the notice of violation, copy of the notice of hearing, copy of the posting affidavit, a photo of the notice of hearing posted on the property, and a pre-hearing order.
Okay. Exhibits A and B are admitted as evidence. All right. Please proceed.
Okay, so on May 30th, 2025, I conducted an initial inspection and observed the vacant property to be in violation. On June 23rd, a corrective action inspection was conducted and photos were taken and the property remained in the same condition. And as of my final inspection on August 18th, the property still remains in the same violation.
What is your recommendation?
On that one, it is $200 a day.
Okay, 14 days, $200 a day.
Last case, WPRE Ventures 1 LLC, case number 2025-863. Code Officer Cody McGuire. Joanna Katu is the expert. Page 41 of your agenda.
All right, Cody McGuire, Citrus County Code Compliance Officer, case number 2025863, special requirements for all accessory structures, a violation of Citrus County Land Development Code 3102A. Address is 7676 West Rainbow Street, Denellen, Zone CLR, and is 0.48 acres. The property owner is WPRE Ventures 1 LLC. Good service via posting the property and at the Lecanto Government Building. I'd like to authenticate the following documents and request that be admitted into evidence. Exhibit A is photos taken during initial inspection on May 30th, corrective action inspection on June 23rd, and my final inspection on August 18th of 2025. And Exhibit B is a copy of the notice of violation, copy of the notice of hearing, copy of the posting affidavit, and a photo of the notice of hearing posted on the property, and a pre-hearing order. You're going to see similar photos because they're next to each other.
Right. All right. These documents are admitted as Exhibits A and B in evidence. Please proceed.
Okay. And then on May 30th of 2025, I conducted my initial inspection and observed those items on the vacant property. On June 23rd, a corrective action inspection was conducted, and I believe an RV was added. And then on August 18th, my final inspection, the property remains in violation. And the property owner did call out to me and told me that he was going to take a trip from, I don't know where he was.
Chicago?
Could have been. And have it removed. And he told me he was going to call me back after he inspected it, but I never heard from him. I reached out to him, and I've had no contact
I
after
saw
that.
the mailing address was Chicago, but it's interesting how this happens on so many parcels. I mean,
These
it's a
people were
lot.
sold on a ticket that they were able to move their RVs out there and rent that parcel of land and basically use it as an RV park.
All right, well, what's the county's recommendation?
Same as that one, $200 per day.
All right, 14 days, $200 a day.
Thank you.
Okay, now that was the last case. Is there anything else that the county wants to take up before the hearing is concluded? All right, the time is 1:21. This hearing is adjourned.